page, I'll know you're ready. Michelle,
Yes.
and you are ready, Ms. Smith?
I am, yes. I apologize for yesterday. I figured out what happened. I set up a new place and I thought I was all plugged in, but the outlet didn't work. So I was running on battery and I didn't realize it. And then all of a sudden my battery quit on me. So that was one of those fun days. But I found it in the YouTube and I've written it and it is now incorporated into the transcript yesterday. So we're good. The transcript's good.
Good.
Pardon me, Chair Duffy.
Yes,
Michelle, if you can hear me, can you give us a full participant view at some point?
yes, she
What?
will pull down the evidentiary here.
Yes, I'm ready to do that now if your guys are ready.
We are ready. Good morning, everyone, and welcome to day 2 for the hearing of docket number 18 WSEE 328 RTS. And as we last left, we were ready for witness Richard Mackey and Ms. Kafer. There you are. And you are muted, Ms. Kafer. There we
Got
go.
it. Okay,
Okay. Will you tender your witness?
yes, thank you. Southern Pioneer and Pioneer Electric call Richard J. Mackey as a witness. Will you state, Mr. Mackey, I can see you.
I need to swear him in.
Go ahead.
Sir, if you'll raise your right hand, do you solemnly swear that the testimony you're about to give and the cause now pending will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you.
Okay, will you state your name for the record, please?
Richard Mackey.
And are you the same Richard Mackey who caused to be filed in this docket cross-answering testimony consisting of 17 pages?
Yes, I am.
I would ask you the questions that are contained in that pre-filed testimony today. Would your answers be the same?
Yes, they would.
Do you have any corrections you need to make?
No, I don't.
Okay, I'd like to move for the admission of the pre-filed cross-answering testimony of Richard J. Mackey, please.
Is there any objection? Seeing none, it is so ordered. Thank you.
I'll tender Mr. Mackey for cross-examination.
Very good. We will be going in the same order from yesterday. So beginning with James Flaherty of the Liberty Empire.
No questions, Your Honor.
Thank you. Next, we will move to KIC Robert Benson.
No questions, Your Honor.
Thank you. Susan Cunningham with Keck, Kepco, Midwest, and Sunflower.
No questions, thank you.
Thank you. Mr. Joseph A. Strap with Curb.
Yes, I briefly have a couple questions. May I proceed?
Yes, please.
Thank you. Morning, Mr. Mackey. Can you hear me okay?
I can. Good morning.
Thank you. I just want to talk briefly about the proposal you're making to the commission to establish this new process regarding the DG services among utilities, okay?
Certainly.
Real quick, I was going to email about appearances. I may have missed them, but just to clear for the record, Joseph A. Strap on behalf of Curb, along with David Nickel or David W. Nickel and Todd Love. Sorry about that. And back to my questioning. So as far as this process goes, Southern Pioneer is envisioning something that requires each utility to file an application regarding service.
I'm not sure I understand the question.
One moment. As far as your idea that Southern Pioneer's proposal that there should be some type of service that separates DG customers from non-DG customers, is there a set list that needs to be approved, or is each company to do their own approval what services they're providing to DG customers to justify different charges?
Yeah, well, that's under my reading of the Supreme Court decision. It's necessary under 117D to establish that there is different services being provided to DG. And I believe it would be the burden of the utility to prove and identify what those services are
Okay.
prior to having a rate approved by the commission.
Okay. And through this process, it would require a kind of just like the formal KCC procedures and application, and people get intervene and comment on the application itself. Is that what you envision?
That's what I envision. I don't know, there could be other options, but that's what I would envision.
Okay. And these applications, they would require kind of the full gamut of participation from parties. Is that what you envision as well?
Again, I wouldn't be the one to set that procedure,
Sure.
but that would be one way to do it. That's probably what I had in mind. Yes.
Okay. And now I'll turn specifically to Evergy and their rate design for this docket, okay? So under your proposal, would Evergy need to come back with a separate application to go through a proper procedure specific about what services it's offering to DG customers? Or is this docket supposed to be the precedential format for how it should go for every utility going forward, in your opinion?
I don't know that Evergy would need to come back with another docket to establish that, but I wouldn't also say that this would become a precedential case that shows how every utility has to do it. Does that answer your question?
It does, thank you. I have no further questions.
Thank you. Next, CEP, Sierra Club, Vote Solar, Mr. David Bender.
Before we begin the Sierra Club, I think some of the commissioners wanted to
Yes, and
go first.
I thought we would do commissioners right after staff, if you don't mind. Commissioners, I'm sorry, I'm not used to commissioners going first, and it did just, unless commissioners, do you want to go right now? Okay, let's.
Madam Chair, I would prefer to go now if I could.
Okay, all right, great. Commissioner Keen, please, and I apologize.
No, it's fine, no problem. I think some of the other questions that are asked are really a bit more specific. I think we can provide kind of some overview questions, perhaps. Good morning, Mr. Mackey.
Good morning, Commissioner King.
My first question to you is, as I understand your testimony, it is your opinion that the Supreme Court order does not restrict residential rate structures that contain separate rates for different services, in as much as I understand your testimony, those arrangements would not constitute price discrimination under either KSA 66, 117D, or the order. Is that correct?
That is correct.
Again, if I'm reading your testimony correctly, it appears to me that you generally concur with Evergy and with the KEC group that in this instance, the proposed grid access charge is the preferred rate structure for residential DG customers. Is that correct?
Yeah, I would characterize it that way.
Please qualify it to any extent that you feel most comfortable. I'm not
Sure.
I'm not trying to lead you in any specific direction. I'm just trying to resolve some overview questions.
Certainly. No, I appreciate that opportunity. I would characterize it as we are supportive of that type of a mechanism, with the caveat that we are not and have not expanded our scope into evaluating the specific inputs to the calculation and the reasonableness of the result of Evergy's proposal on the magnitude of that charge and how it's applied. But generally speaking, yes, we would prefer a grid access fee as a more appropriate design for accomplishing what they're setting out to accomplish.
Fair enough. I appreciate your qualification and the nuances of that. Glenda, if you would be kind enough, or whoever has access to what I think's been identified as Pioneer Exhibit number 1, if you could put a screen share on page 3 of that exhibit, I would appreciate it.
Will do. Sorry.
Glenda, you've sent me a copy too. I can get it if that's easier.
I can
That's
see
it.
it. I got it up.
Thank you, Glenda.
Yes.
Mr. Mackey, let me ask you this question. Is it fair to say that this exhibit summarizes and identifies the service distinctions or substantive differences between the grid access, that is between the services provided to DG customers versus those not provided, or those provided to non-DG customers?
Yeah, that would be a fair description. These are services that DG customers use. I would not say that in all cases there are different types of DG customers, but the customers we are talking about here take these types of services, and that's what distinguishes them from non-DG. Non-DG customers do not take these services.
All right, thank you. In your opinion, would these service differences support a utility's proposing rates that impact DG residential customers differently than non-DG customers?
In my opinion, yes, it would.
Again, in your opinion, would these service differences materially assist, support, or bolster a contention that the grid access charge passes lawful muster under the terms of the Kansas Supreme Court remand order in this instance?
Again, I don't want to give legal advice, certainly, but
without making you a lawyer.
certainly, in my reading of the Supreme Court order, the Supreme Court did put squarely at the center of this discrimination claim whether the rate being charged was for the same service or different services. The Supreme Court order did not contemplate any of the services, at least that I've seen in the order, any of the services that are on the screen in front of us today in making that determination. So it's my opinion that if a rate is designed around these additional services provided to DG that are not provided to non-DG, that it would comply with the framework and the spirit of the Supreme Court decision.
All right, thank you. Let me ask another question to maybe put a little finer point on that and elicit your views. In view of your testimony, why do you believe that the proposed grid access charge would pass lawful muster under the, I'm not trying to put words in your mouth here either. You can qualify this to the extent you want. Let me start again. Why do you believe that the proposed grid access charge passes legal muster under the Supreme Court opinion when the demand charge as part of a 3-tier rate structure was found to be unfairly discriminatory against the residential DG customers?
Well, that's a great question, Commissioner Keene. Let me try to answer that. The 3-part rate structure was differentiating based upon load, and it's billed based upon load. And it was presented by the company and approved by the commission as a rate applied against load. And it was also, according to the Supreme Court decision, it was presented that way with the assumption that 66-1265 preempts 66-117D. And so it's presented as a way where the utility believed they could charge more for providing the same service. That's right out of the Supreme Court decision. So that was how it was brought forward, as a rate that the utility acknowledged could charge more for the same service. The court has determined that that does not meet 117D, and 117D needs to be viewed in light of 1265. So in order to work those together, you have to establish that there is a separate service. That service is related to the generation, not the load in this case. So being a generator is what results in these types of customers having a different type of service. The grid access fee is designed around that. It's designed around the size of the generator, that when it intermittently stops producing, the grid has to back up and provide the electricity. So that's a benefit certainly to the DG customer, because it provides the DG customer with the same reliability as a full requirements customer, right? So it's based squarely on the size of the generator, and the size of the generator determines the charge in Evergy's proposal, and it relates to how much grid capacity needs to be there to back it up. So it is not based upon load like the three-part rate, which is different from being based upon the generation of the customer. And the generation of the customer is squarely and more directly tied to the separate services that are being provided. Does that answer your question, Commissioner?
Thank you very much. It's very articulate and it was very nuanced. Glenda, as we proceed, would you be kind enough to remove the page 3 from the Exhibit 1?
Yeah.
There we go. Thank you. Again, Mr. Mackey, I want to try to mine the dearth of knowledge and experience that you have a bit further. As between the grid access charge and the alternative that Evergy has proposed to that charge, which would be the minimum bill proposal, do you prefer one of those over the other? And if so, why?
So as it relates to the two options presented by Evergy, one being the minimum bill, the other being the grid access fee, I believe either are compliant with the directions and the guidance provided by the Supreme Court. I don't believe either are unduly discriminatory. And so after clearing that hurdle, I think it's up to the commission, right, and the parties to determine what is the most appropriate rate. And for that, when I look at this, I view the next issue is being the cost shift issue, which does relate to how the two-part rate performs across a increasingly diverse group of residential customers, a group of customers that now is not just consumers, but as it was said yesterday, prosumers. They're putting power onto the grid. And that has a big impact, not just on how the grid operates, but it does also affect significantly the load characteristics of the customers that are all served under that two-part rate. Load characteristics may or may not be descriptive of a different service. They may go hand in hand with that different service, but regardless, they typically affect the cost to serve the customer. So that's the next decision, is how do we get at this issue, which is the cost of service? And it's the cost of service issue that's resulted in some parties in the commission determining that there is a cost shift in this situation because of the impact on the load characteristics. And so that being the issue in play, my preference would go towards the grid access fee as a more direct way of addressing the issue at hand, which is the cost shift. versus the minimum bill, which accomplishes some of the same things, but it also broadens the scope to affect low use customers that do not have DG.
Thank you for that answer. I want to ask a question of you that I asked both of Dr. Ferraghi and of Mr. Lutz yesterday. Since the minimum bill proposal, if it were adopted, would affect all residential customers, as contrasted with the grid access charge, is there any risk that an effect of the minimum bill proposal would be to either further defer, would be to further defer basically the prospect of narrowing or eliminating the purported subsidy or free rider problem?
That's a good question. I think I would maybe go back into the question a little bit. It's my understanding that the minimum bill option being proposed would not necessarily affect, maybe this is a nuance, right? It may not actually affect all customers, because if you use more than, if your bill under the rate exceeds the minimum won't affect you. Maybe that's a nuance. It will apply to everybody, but it may not actually affect everybody, if that makes sense. But then back to the heart of the question, I think it will, a minimum bill would still get at the issue at hand, but it does so in a very blunt way that it probably doesn't have it wouldn't have the degree of impact and precision that the grid access fee would have.
All right. Two more questions for me. I would like to garner your overview or summary of the proposals advanced by other interveners. Your take on the staff, KCC staff proposals, pro and con.
Well, as I understand it, staff's proposal is for, it favors the minimum bill. And so I guess I don't have, other than what I've already commented on and my preference for the grid access fee, I guess I wouldn't have any additional comments on that proposal.
That's fair enough. Same question with regard to the CEP group and their proposals.
Well, I would be in disagreement with their proposal, because I believe that there is a path forward for the commission if it is first determining that there's a different service being provided, that clears the hurdle set up by the Supreme Court, and then it's within the court, the commission's jurisdiction to determine the appropriate rate design for that group of customers receiving a different service. And for that purpose, the issue at hand is, how do you ensure that the rate is fair to that group of customers? And the grid access fee is designed in a way to reflect the services being provided. And so again, I would disagree with CEP. I think there is a path to move forward, and that the grid access fee is a viable path forward.
All right, thank you. One final question for me. If you could, you have available to you the Pioneer, the papers here. It'd be the Pioneer reply comments, in particular, page 7.
I don't have real quick access to that, but maybe someone could put it up on the screen for me.
Glenn, is that accessible?
Yeah, I just need this.
Sorry to do that to you.
No, my apologies. Yeah.
That's okay.
Let me get it here. Did you say initial or reply comment, sir?
The reply, please. Page 7.
Page 7. Oh, okay.
Glenda?
Yeah, I'm here.
Don't worry about it. Let me, Mr. Mackey, I'll simply repeat what appears on that page that I'm looking for here, and then ask you the question if I might.
Certainly.
It's fine, Glenda.
Don't need it now. Okay.
Oh no, it's all right. If you want to go ahead and find page 7.
Finally.
Paragraph 16. You're about there. You're right there. There. That's fine. Thank you. Mr. Mackey, if you could take a look at the first 2 sentences of this paragraph 16.
Okay, I've reviewed it.
For the benefit of the record, if you could again summarize, this is the curb position or an aspect of it that you're taking issue with. Can you expand on this a bit for the benefit of our record?
Sure, certainly. In this paragraph, it's building upon a discussion of the two-part rate and really the traditional evolution of rates over time, especially in regulatory environments, where the rate structures oftentimes don't reflect cost structure. And what I mean by that is fixed costs are recovered in variable charges. Now, one solution to that and some of the issues that we're starting to see with that regime is the issue that can result in subsidization or cost shifting. And one of the solutions is to move then fixed costs into the fixed charge. And one of the issues that a lot of times comes up with that is the impact it has on low usage customers. In this specific paragraph, what I'm discussing is that low usage customers are not necessarily the same as low income customers. And that may not be super, really clear based on some of the terminology being used, but that's what's meant by this, is that low income customers are not always low usage. And that's especially true when you look at rural utilities such as Pioneer. Pioneer does not serve high dense areas with high-rise apartments or low-income housing. A lot of Pioneer's low-income customers live in rural areas. They live in homes that are not as well insulated, with appliances that are not as efficient. And many times, in some of the work I've done to evaluate this, shows that low income are just as likely to be high users as they are low users. And so in that case, many low income customers would benefit from moving fixed costs into the fixed charge, because it would result in a reduction of the energy charge. And a lot of these low income customers have a lot of energy, and so they would actually benefit from it. So that's what I'm pointing out here, is it might be more true, right, that low income is low usage for some utilities, especially maybe if they're serving more of an urban core. But it's definitely not something that should be applied universally to all utilities, especially when you get into more rural-based utilities such as Pioneer.
Thank you very much. Again, a very nuanced answer. I appreciate that as well. I have no further questions at this time. Thank you.
Thank you, Commissioner Keen. Commissioner French, please.
I was actually initially planning to reserve any of my questions, if any, until after the party. So I think I will continue to do that.
All right, thank you. I as well will wait till after the parties are completed. So we will move on. And I believe we were right with Mr. Bender with CEP, Sierra Club, and Vote Solar.
Thank you, Chair. Good morning, Mr. Mackey. I just have one or a couple of questions to follow up. You had just had in front of you Pioneer Exhibit 1. There's a list of differences or services to DG customers. You recall that?
Yes, I remember that, yes.
Okay. Is that list of services to DG customers, is that essentially a list of services to partial requirements customers?
I believe partial requirements would also utilize some of those services at least.
Okay.
Not necessarily all of them, but they could.
And you said the same thing about DG customers, right? They might utilize some, but not necessarily all of that list.
Yeah, for example, there's customers that have DG, like commercial, industrial customers, or it could even be a homeowner that has a backup generation resource like diesel or something that it's actually the exact opposite of what we're talking about. What we're talking about is solar customers that use the grid as a backup, but there's also customers that use the grid and have their own backup, right, through some sort of distributed generation resource. So yeah, there's certainly different kinds. So there's also DG customers that use their generation for peak shaving purposes. But what we're talking about here is solar customers that use their DG system and rely upon the grid for backup through an interconnection.
Right. And you would also consider that to be partial requirements customers was the question. I think the answer was yes. Is that correct?
That I would also consider who to be partial requirements customers?
DG solar customers.
Yes, I would.
And that list that we talked about, Pioneer Exhibit 1, is a list that you would apply to DG solar customers and to partial requirements being synonymous.
Sure. Yes, I think the list applies to both, yeah.
Okay. Your testimony here this morning was that you didn't think that the Supreme Court's, in its decision, considered those factors as being a difference in the service received by DG customers, correct?
When I looked at the Supreme Court order, I do not see any discussion of those types of services as a basis for how they evaluated the rate.
What did you do to inform yourself about what the issues were before the court? Did you read anything beyond the court's opinion?
I reviewed some testimony and but mostly it was the Supreme Court decision.
Did you review any of the briefing?
I did not.
I have nothing further. Thank you.
Thank you, Mr. Bender. Next, we turn to Carly Messentine with staff.
Good morning, Mr. Mackey.
Good morning.
Thank you for your participation in this docket and the hearing today. I have just a few questions for you. Some of these you may have touched on already in answers to previous questions, so feel free to modify as you would like. All right. In your testimony, you state that DG customers receive an additional service, which justifies charging the grid access fee. Could you please explain the difference in service, just a brief overview of the difference in service that DG customers do receive compared to regular residential customers?
Yeah, certainly. The DG customer has a completely different arrangement with the grid. they receive an interconnection with the grid that allows their generation facility to operate in parallel with the grid. And that allows for real-time import-export balancing of load that certainly customers without DG do not need, do not benefit from, and do not receive from the utility. I mean, there's interconnect agreements, there's standards. IEEE has a document, it's 120, 130 pages long on how utilities need to and should go about interconnecting with these types of customers. Clearly, that type of a standard does not exist for a non-DG or for a customer that puts in an energy efficient air conditioner, right? There's a clear difference between customers that are making a decision and benefiting from the installation of DG and how that impacts the grid versus customers that are not. It's a completely different arrangement. It goes beyond the impact on load characteristics. Load characteristics are important for establishing costs and rates, but it's an independent distinction, an independent decision from the development of rates as to what type of a customer this is and what types of services they're receiving from the grid to really allow this customer to be a partial requirements, to be able to self-supply part of their load, but receive the reliability that a full requirements customer gets by using and having the grid fill in the gaps of when their DG system is not operating.
Well, as we've discussed previously, the court stated that DG customers and residential customers received the same service. Could you help me understand how that fits with the distinction you're making in services, or if it does?
Well, again, I don't want to make a legal conclusion, but I would take a little bit of issue with the assumption in the question. I don't read the decision as establishing once and for all that DG doesn't receive any different services from non-DG. I read the language of the decision, to me, says that the rate, they were evaluating a specific rate proposed and approved by the commission for whether it met the requirements of 117D. And within the context of that rate, they said that the rate was not based upon a different service. It was the rate which was based on load, not the generation, it was based on the load, that was not related to, it was charging more for the same services, which again would be the load. So I don't believe that it would need to be interpreted as the court decided that DG doesn't receive any different services. Within the context of how this rate was designed, the rate was not designed. In fact, the tariff that implemented the rate made no distinction. So there's a tariff for standard residential and there's a tariff for residential DG. That tariff in the availability and the type of service provisions said nothing about what additional services this new rate schedule was for. All it did was identify that it was for DG. And so to me, that's how the court decided, well, that tariff really is only based on a customer's DG status then, because it doesn't describe anything different in terms of the service between what a DG customer was getting versus a non-DG. So again, I think the decision was based narrowly around the rate that was proposed by Evergy and approved by the commission, and whether the court felt that it was adequately based on a different service, not whether DG actually received a different service or not.
Mr. Mackey, would it be fair to say that in the context of the grid access charge, there's three cost components there? There's demand costs, energy costs, and the export function costs. Is that correct?
Could you repeat the question? I'm not sure I'm following.
So there's three different cost components that you think the grid access charge would be designed to recover then? It would recover demand costs, energy costs, and export function costs? Am I phrasing that? Is that correct?
Well, in the design of the rate, it would recover the costs of the grid that are not adequately recovered by the two-part rate. And so that would cover the fixed costs that are allocable to that customer group that aren't recovered by the grid. So it would include capacity costs that are allocable to that group of customers. It could, that would generally be what it would be, is capacity related fixed costs.
Okay. Would the grid access charge recover any of these additional like export costs that DG customers, the types of services that they receive and the extra benefit that they have by being able to export onto the grid? Does the grid access charge recover any of that cost?
I guess this is where I don't think it does, but I'm not maybe privy to how the inputs to the grid access charge were derived. I know there was some discussion on that yesterday, trying to figure some of that out. But my understanding is it's the cost of the grid that is being used to back up the DG system. The nature of the service does allow for export, but I don't know that it's, as you turn then to kind of, okay, we've met the hurdle that there's a different service here, and how do we design the rate? That's a different question.
Mm-hmm.
And whether there's a identifiable cost related to that export or not would be something that Evergy would need to testify on, whether their rate includes that or not.
Well, I suppose it appears to me when I'm looking at the grid access charge that part of the reason why you're justifying the grid access charge is because of these additional services that DG customers receive and benefit from, such as the ability to export onto the grid. But there seems to be a disconnect because I don't know that the grid access charge is directly recovering those costs. As you said, it seems to be recovering the capacity costs, not the costs that are justifying it, what it would be, why it would be legal.
So what's the question? I'm sorry.
Well, I just wondered if you had any comment on that. And more specifically, I was wondering if you had an estimate of what those export costs might be. Are they quantifiable?
I don't know. That's a good question. I don't know that they are quantifiable, and I don't know to what extent it's relevant. I guess the ability to export describes the type of service arrangement the customer has. It's possible that doesn't cause any incremental costs, but rates aren't designed based on incremental costs, right? Rates are designed around an allocation of common costs. And so once you've determined that this type of customer class uses the grid differently, receives a different service, now you go about identifying how do we allocate the common cost to this class? And then in rate design, you decide now how do we go about collecting their allocated costs? So whether you can identify a specific cost for export or not, the fact is if they're receiving a different service, you can evaluate their cost of service given their load characteristics and identify a rate that's appropriate for that class of customers.
Okay. Final question. You mentioned in your testimony that several other states have adopted grid access charges. Would you agree that the statutory framework that would allow for such charge to be legal would vary from state to state?
I would agree that there probably are differences. Yes, I don't know that every state is different, but there certainly would be differences.
Okay, well, thank you, Mr. Mackey. At this time, I don't have any further questions.
Thank you.
Thank Thank you, Ms. Massentine. Commissioner French, would you like to ask questions now?
Yeah, I think I'll ask one or two, although my questions got asked better than I ever could have mostly. So, so this will be quick. Thank you. I want to explore the comment that Commissioner Keene was exploring with you on the minimum bill. And I thought that was a very insightful and helpful comment that low usage does not necessarily equate to low income, particularly in the rural sense, but probably in the holistic sense. And I appreciated that. I guess my question is, you would agree, though, that while this may not be a low income issue, a minimum bill can cause issues for low income folks and may impact them disproportionately just by its very nature, that it is a bill that one cannot escape. And so the folks most unable to pay could be disproportionately impacted, or at least there's a danger that they could be disproportionately impacted by the nature of that type of bill. Would you agree with that?
Yeah, I would agree with that. It's certainly possible that they could be disproportionately affected by the minimum bill, right?
Okay. And then I would just be interested if you have any thoughts. I mean, I want to explore this with all the parties, but if you have any thoughts on the appropriate relief to afford low-income folks so that they are not adversely impacted by that. I think that the company has suggested some sort of self-identification process, allowing customers to gain an exemption from the minimum bill. Staff has proposed trying to do it by dwelling type. I didn't know if in your experience in other jurisdictions, you've seen any other processes, whether you think that there's a best practice that's out there, but I would be very curious.
Yeah, no, that's a great question. And I think that is somewhat of a challenge, right, of wanting to ensure that a minimum bill impact does not disproportionately disadvantage low income. It's a difficult, whenever we deal with low income impacts in rate design, it's difficult to accomplish. It's difficult to identify them. You can have programs that are kind of opt-in, right? But you're not capturing everybody. But you would hope that those that need it are the ones that are recognizing those opportunities and participating. So I don't unfortunately have a silver bullet here or a perfect answer. I think the ones that have been described are reasonable attempts at getting at that issue. But unfortunately, I don't have any probably new contributions to those discussions.
Thank you. I appreciate that. I think at this time, I'm going to resist the urge to pull the Supreme Court opinion back up and ask you about it. And I'm just going to be finished. Thank you.
Thank you, Commissioner.
Thank you, Commissioner French. Mr. Mackey, a couple of issues. As you have kind of a finance background, I'm sure you're familiar with articles about, and I'm back on the issue of low income, where utility bills are a higher proportion, take a higher proportion of their income rather from people with median income. Would you agree?
Madam Chair, I certainly would agree. I'm familiar with those types of articles.
And also, I do agree that low income doesn't mean low usage, because in Topeka, a lot of the housing stock that low income occupy, and I believe this is true in Wichita as well, are larger homes, very poorly insulated, older homes, and most of these folks don't own the home, and they are dependent upon a landlord to do any modifications or any energy saving steps to improve the efficiency. But I do believe a lot of these folks pay the energy bill separate from their rent. Would you agree with that?
I don't have insight into, how many of them individually pay the electric bill, but yes, I would agree with the description in general, yes.
Yes, I think a smart landlord would, especially if he knows what kind of home he's renting, perhaps, and I don't mean to disparage all landlords, but a lot of them really don't care. As long as there's a warm body in there and they're paying their rent, they really don't care, and they do minimum upkeep to the detriment. It's a vicious circle. So I would agree that just because it's low income, it doesn't mean low usage. But as Dr. Faruqi said yesterday, sometimes it's because there's a lot of people perhaps living in that home, but I think also it's because it's poorly maintained. I would like to turn to, you were referring to load characteristics, and that's why there should be a differentiation between a DG and a non-DG. So as we look at the state of Kansas and Evergy and the number of customers that are DG customers, do you think the load that they don't put on the grid because they are self-generating, do you think it is a significant amount?
Yeah, that's an interesting question. In terms of the total load in the state, it's well below, my understanding is well below 1% of the load, or maybe below 0.5% of the load. So from that measure, I would characterize the current state of that as being, it's not significant. The way that the economic incentives and rates are designed going forward are going to help shape how this looks in 5, 10, 20 years in Kansas. And to me, that part of it is significant.
Do you, and when I talk about the load, I am talking about the residential load, not all the other load on there as well.
Certainly.
So you agree it's not significant. So these 850 some users, do you think even in the next 5 years, with the growth we've seen, we've continued to see, do you think the impact on the load will rise to a level of significance in the next 5 years for residential customers utilizing distributed generation?
Well, I mean, this would just be somewhat speculation, but I certainly have seen some of our clients in other parts of the country that this has grown into a more significant issue in a short period of time. This is not, I think we have to be careful too about looking at what might be happening in Kansas as a state versus how it's impacting individual utilities. And so it certainly could look like it's not very significant for Kansas as a state, but for a certain utility, it might have become a significant issue. I've got clients that went from less than 1% of their customers being on DG to over 10 to 15% being DG customers in the matter of 5 years. So it's happening in certain parts of the country. Whether it'll happen and where it will happen in Kansas, I don't feel real comfortable saying yes or no to that. I apologize.
Is that a concern, do you think, for the company you're representing today?
At the residential level,
Yes.
I've heard, they have some concern about this, and let me just speak that concern, it's not so much, it's not a concern about revenue. It's not a concern about overall financials. It's really a concern about whether their customers, and for the case of Pioneer, their members are being treated fairly on a customer by customer basis, you might say, right? And so are non-DG customers needing to pay more than they should to subsidize and pay for the grid that non-DG are benefiting from? So it becomes more of a fairness issue, and it also becomes a economic, how is Pioneer and Southern Pioneer contributing to the decisions their customers are making? Because they don't want to, as a utility, they don't want to take what might look like an insignificant amount of load today and have policies in place that drive development of that and make it an issue, and now have to try to deal with it and potentially play with or extend payback periods from their customers. No one wants kind of the proverbial rug pulled out from under them. So there's a concern that you're providing your customers with a sound basis to be making these economic decisions that make sense going forward, that you don't have to change the rules of the game at a later point once a more significant amount of this load has developed.
So it really comes down to, as the slide was put up, about the different services that are provided to DG customers versus the load they're not using. So are you saying it's?
Yeah, I would agree. It's because it's not a load issue, because whether the load goes up or down, the distribution system remains there. And the distribution system remains there to provide those services that you're referencing that the DG customers are still taking. And so it's really about how do we ensure that those services and the grid that's providing those services is getting paid for by the right people.
Okay, thank you. And thank you, Mr. Mackey, I appreciate it. I know you're limited on your time. It is 10:11, and I'm turning to Ms. Kafer. Will your witness be available after 10:15?
He thinks he'll be done around 11:45. He can't guarantee that, but he would definitely be available, come back when we come back from lunch and finish up if there's anything.
If there's no objection from the other commissioners, I believe or if you want to, Ms. Kafer, get in your redirect, that's fine, your choice. Either wait or we start with that when he comes back.
Okay. It's 10:12, so I can do it when we get back.
Okay, Mr. Mackey, thank you. We will see you later, and we'll take up where we left off.
Thank you, Madam Chair.
Thank you.
Next, our witness is Douglas Shepard. Yes, Ms. Cunningham. And first, we do need to swear the witness in. Ms. Smith.
Sir, if you could raise your right hand. Do you solemnly swear that the testimony you're about to give and the cause now pending will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Good morning, Mr. Shepard.
Good morning.
Would you please state your name and business address for the record?
My name is Douglas S. Shepard, 7332 Southwest 21st Street in Topeka, Kansas.
By whom are you employed and in what capacity?
I'm employed by Kansas Electric Cooperatives as the Vice President of Management Consulting Services.
And on whose behalf are you testifying today?
I'm testifying on behalf of KEC, Kansas Electric Power Cooperative, Sunflower Corporation, and West Energy. In our testimony, we've referred to this as the KEC group.
Are you the same Douglas S. Shepard who filed cross-answering testimony in this docket on November 23rd, 2020?
I am.
Would you please briefly describe the purpose of your testimony?
Yes, my testimony was to respond to some of the direct testimony filed in the remand case by Mr. Brian Kalsick on behalf of CURB, Rick Gilliam on behalf of the Climate Energy Project, Sierra Club, and Vote Solar, and Robert Glass for the commission and staff.
Was your testimony prepared by you or under your direct supervision and control?
Yes, it was.
Do you have any additions, deletions, or corrections to make to your testimony?
No corrections to the testimony. We did find a couple of revisions that we need to clear up on some of the footnotes. I apologize for that, but page 4 of my testimony, footnote number 4, refers to Glass testimony. That actually read Kalsick testimony, footnote 4. And then on page 6, footnote 9, the reference there is correct, but it should also include an addition to refer to Glass testimony, page 6, lines 26 to 30, and page 7, lines 1 to 2. And then one more on page 12. Footnote 17 refers to Gilliam testimony, and the reference on page 5 should be struck, and it should instead say page 38, lines 21 to 24, and page 39, lines 1 to 4. And that's all.
Thank you, Mr. Shepard. Now, with those corrections to the footnotes that appear in your testimony, to ask you the same questions today that appear in your testimony, would your answers be the same?
They would.
Thank you, Mr. Shepard. Madam Chair, at this time, I would move for the admission of the cross-answering testimony of Douglas S. Shepard as corrected today, filed on behalf of the KEC group, and that I would tender Mr. Shepard for cross-examination and commission questions.
Thank you. Is there any objection? Seeing none, it is so ordered. So we will begin with commission and the commissioners, and Dwight Keene. Yes.
Thank you. Thank you. Good morning, Mr. Shepard.
Good morning, Commissioner Keene.
A couple of questions for me. And I'm basically referring to your cross answering testimony generally. I think my first question, Mr. Shepard, would be that it is, as I understand it, and again, if I misstate the question, you can rephrase it in a way you feel comfortable. I'm not trying, I'm really trying to elicit the information. I'm not trying to mousetrap anybody here. As I understand your testimony, you're claiming that since all customers are subject to the grid access charge, it would be non-discriminatory as opposed to the demand charge that was found to be discriminatory. And as I understand your testimony, you believe that's the case, even though some customers may pay a zero bill under that charge. If I generally reflected a portion of your testimony?
Yeah, I think that would be accurate.
Then if you could just answer, why is it that you believe that's the case?
Okay. So I think really the way that I laid it out is that all customers are subject to the grid access fee, even though you might not have a connected generation, so you would have no billing determinants. Dr. Faruqi really laid it out well yesterday, where he showed that or described that all customers can interact with the grid in two ways, either as a consumer or producer. And those that do both, he labeled or used the term prosumer. And so by separating out the customers that import versus those that are connected and have their and that are exporting, that kind of summarizes that all customers would be subject to both charges. But if you're a producing customer or you're a non-producing customer, you have zero billing determinants.
Okay. I appreciate that. My next question really is that as again, as I understand your cross-answering testimony, you were concerned with regard to the CEP group approach, as I understand it, because you did not believe that, I'm trying to phrase this in a really generic way, that they did not take into account that basically DG and non-DG customers in effect exhibit different energy flow characteristics and are not receiving the same service. Is that a fair summary of a portion of your opinion and your testimony?
I'm not clear specifically what you're referring to about the CEP approach. I do agree with your summary that where I was summarizing that I believe that they take DG and non-DG are different types of customers.
Okay, can you expand on that just a bit?
Well,
in asking that, I grant you that we have asked similar questions now of Mr. Lutz, of several of the witnesses, Mr. Ferrogi, and all the other witnesses. But I'm interested in your take on that from your perspective.
Yeah, so I think maybe I'll address maybe what you're asking me is why do I believe there are different types of services? A DG is different than a non-DG.
Well stated. Thank you for restating my question.
Okay. So in our initial comments and in my cross-answering testimony, I think we laid out that DG customers interact with the grid in a different way. And that is, one, they are partial requirements. So they generate their own electricity, and that when their generation is not producing enough to meet their needs, then they draw upon the grid. They also are an export during those times when they're producing more than they need. And so that bidirectional, they have the ability to not only import energy, but then also export energy. And then when they export, what they're doing is we're not really storing the energy because you can't store it. It gets consumed somewhere else, but we're giving them credit for that. So there's a credit that is accounted for. And so that later on at night or some other time during the billing period, when they need to draw on that, they can use those credits. So we sometimes say storage, but the term I like to use is a virtual storage. We're not really storing it, but it's a virtual storage of those credits. So those three characteristics, I think, give you the path forward to recognize DG customers are different. They engage with the grid differently than non-DG customers. And because of that, they ought to be treated as different, not because they're renewable, but because they interact with the grid in those at least three ways. I think in a fourth that I didn't really articulate in my testimony is that their load profile is different. Not only their way that they import and export, but even the net profile is different than a non-DG customer. Does that answer your question?
It did. I appreciate the answer. Appreciate all of your testimony as well. I have no further questions at this time.
Thank you. Commissioner French.
No questions. Thank you.
Thank you. So I will ask you again. So your comments to Commissioner Keen, Mr. Shepherd, you state that you don't believe it really should be referred to as storage. They send it, the DG customer sends electricity back out on the grid, but it's not being stored in a location per se, correct?
We're not storing the energy, we're storing the credits. So it's a
Storing.
virtual storage.
It's a virtual storage.
Yeah.
And then when they need electricity late at night or whenever, then they're receiving electricity like everybody else.
Yeah, that energy that they're importing at night is ticking off or using up those credits before they start getting charged for kilowatt hours. They're using their own virtual stored credits first.
Okay, all right, very good. All right, thank you. That's all I have as well. So let's begin with Pioneer, Southern Pioneer. Ms. Kafer.
No questions, thank you.
Liberty Empire, Mr. Flaherty.
Yeah, thank you, Your Honor. I don't have any questions, and I don't know if it matters, but maybe for due process reasons, I noticed in the script that Evergy is not listed as one of the parties asking questions. I doubt that they have questions, but I thought I'd just bring that up for due process reasons.
Oh, I do think that is important. Thank you.
And Chair Duffy, I did indicate at the pre-hearing conference that we did not have questions for Mr. Mackey or Mr. Shepherd. So I assume that's why Mr. Fedotin left us off of at least the initial list.
Okay, thank you. All right, very good. All right, KIC, Mr. Vincent.
Thank you, Madam Chair. Good morning, Mr. Shepherd.
Good morning, Mr. Vincent.
Nice to see you. Do you have a copy of your testimony in front of you?
I do.
Mind turning to page 6 for me and let me know when you're there?
All right, I'm there.
On lines 11 through 20, you testify regarding the Kansas retailer's sales tax. Is that a fair statement?
Yes, that's right.
And you note that the legislature set the tax for certain utility sales at 0% when they could have just exempted the tax. Fair to say?
That's correct.
Have you reviewed any private letter rulings from the Kansas Department of Revenue regarding this particular portion of the tax code?
I've reviewed them, but I'm that relate to the 0%
Yes.
assessment. Yes.
And can you describe what those private letter rulings involve?
Well, the one that I'm thinking about is the application, because the 0% is applicable to not just residential but agriculture use. And so my purpose of reviewing that one was what's the definition of agricultural use? I'm not sure that gets to your question, but that's the specific one that I was reviewing, not in preparation for this docket, but.
No, that's the very point I'm trying to get at. There is a private letter ruling that indicated the legislature needed to set this sales tax rate at 0% in order to avoid any confusion on whether a locality could still charge sales tax, correct?
That's correct.
So there was the legislature did have a reason on choosing 0 rather than just exempting the sale outright. Fair to say?
That's correct.
Thank
you.
The
0.
Yeah, thank you, Mr. Shepherd. That answers my question, but I don't want to cut you off.
I was just going to add to that although the state rate is 0, they are still subject to the county tax, whatever that might be.
Thank you, Mr. Shepherd. KIC has no further questions.
Thank you, Mr. Vincent. We turn to Curb and Mr. Astrap.
Yep, I'm here to start my video. Thank you. May I proceed?
Yes, please.
Thank you. Good morning, Mr. Shepherd.
Good morning, Mr. Astrap.
I want to talk to you about your review of Curb's proposal in your testimony, okay? I just want to summarize. I think what I took away is two key points you made regarding Curb's testimony. The first would be is that Curb's solution does not translate into immediate mitigation of RSDG cost shifting, but rather kicks the can down the road until Evergy's next rate case. Is that one of your concerns about Curb's proposal?
That's correct.
Okay. And a second one is that there's no certainty associated with the recovery process under Curb's proposal.
Yes.
Thank you. Let's start regarding the mitigation of cost shifting. Okay. Back when the commission approved Evergy's three-part demand charge rate for RSDG customers, did this provide immediate mitigation of the cost shifting?
I didn't catch the beginning of your question. I just heard
sure.
out.
Yeah, sorry. Yes. My first part of the question was back when the commission approved the previous three-part rate design with the demand charge in this case, did that provide immediate mitigation of the cost shifting from DG customers?
I believe it would. If you're talking about the three-part rate, that the demand rate that was initially approved, did that mitigate the cost shift? I don't know that I wasn't privy to all of the cost of service study, but it would go towards mitigating the cost shift. Yes.
And we say that, you mean the revenue generated from the demand charge, correct?
Well, the revenue generated for the entire DG class.
Sure. Okay. But specifically, the inclusion of the demand charge played a part in mitigating the cost shifting or no?
That's correct. Yes.
Okay.
That's my
so
understanding.
Now that the demand charge has been determined to be illegal, is Evergy permitted to keep this revenue generated from the demand charge? Or should they have to return it to those DG customers?
That's a legal question. I'm not sure I'm qualified to answer. Would think that right now they're operating under a KCC order of rates, and until the KCC orders that seems a KCC determination, and I wouldn't have an opinion on that.
Oh, let me phrase it that way. Do you have an opinion about whether or not Evergy should return the revenues generated under the now illegally declared demand charge?
I don't think so. I think my opinion, that they would this would be a going forward matter.
Okay.
Once the rates change. Yeah.
Okay. Let me go another way then. So hypothetically, if the commission does order the refund of the revenue generated under the demand charge, would any sort of mitigation of the cost shifting that's associated with the demand charge go away?
If they order, those seem two separate questions. If they
hypothetically speaking, if the commission does order a refund, doesn't the cost shifting mitigation associated with the demand charge go away? Doesn't that benefit just kind of become a wash?
If they ordered the refund, the cost shift is still then. If they ordered a refund to the DG customers, that cost shift doesn't go away.
Okay. So let's turn now to Curb's proposal. Can you tell us what the immediate harms are that are associated with Curb's proposal and its failure to provide immediate mitigation of the cost shifting?
Well, I think the immediate harm is that it's been stated several times in this docket or in this hearing that the adoption of solar is not slowing down. In fact, it's increasing. And while now it is a immaterial, insignificant amount, it's going to increase. And so I think the harm is if we don't fix it now, that it's going to become a bigger problem down the road. That's why I think it's important that we do go ahead and resolve it now.
Okay. And can you pinpoint at least just a general timeline of how far down the road before we start seeing tangible problems associated with the subsidy?
Every utility, I represent 29 distribution co-ops, and across those, we've got some that hardly have, very little rooftop solar. We've got others that have quite a bit. In fact, we've got one co-op that's already reached its 5% max of its total load. So, It really is dependent on how close they are to a probably more likely an area that have DG installers or solar salesmen that are promoting it. But I think that a couple things you're going to see if the problem is not fixed, the improper pricing remain. That's going to further encourage adoption. And I'm not saying that I'm opposed to the adoption. I'm opposed to the cost shift. So not fix the proper price signal will encourage more adoption. I think with the recent outcome of the election, we're likely to see reinstatement of the income tax hits. And so and then thirdly, the price is considerable in terms of the price of panels and installation. So the perfect storm, there's a lot of things that are going to promote more and more adoption, whether it's 3 years, 4 years, 5 years. It's hard to say, but I will say as I said, we've already got some that are already bumped up against their limits.
Okay. You've had a chance to review the testimony from all the parties regarding Evergy's proposals, correct?
Yes.
And specifically in reference to the GAF and separate services used by DG customers, there's been a lot of discussion about the legality of that, correct?
Yes.
And in regards to Curb's proposal, there's been no discussion about the legality of Curb's proposal, has there?
I don't believe so. You're talking about your proposal just to record a regulatory asset?
And put everybody back on the two-part rate, correct?
Right.
Moving on now to the issue of revenue recovery rather. You'd agree with me that either under either the GAF or the minimum bill, Evergy would be then generating revenue at a different level than what was previously collected under the demand charge.
That's correct.
And as a result of that, both the GAF and the minimum bill will require some special regulatory accounting mechanisms, correct?
What are you referring to, accounting mechanism? I mean, like any rate has an accounting mechanism with it.
Well, specifically regulatory liability regarding overcollection of revenue compared to what the demand charge was covering, right?
Oh, I don't recall that being part of the proposal, that there would be a regulatory accounting of the revenues from the three-part rate or revenues from grid access fee, unless you're talking about Curb's proposal. Well, no, I don't recall that.
So you don't recall whether or not Evergy has proposed to also include some type of regulatory accounting mechanism to track changes in revenue collection after implementation of either bill or either proposal?
It's not coming to mind. I apologize. I don't recall that.
All right. Well, so let's assume for a moment, subject to check, that there is going to be some required regulatory asset or regulatory liability with either the GAF or a minimum bill, okay?
Yes. Okay. Subject to check.
Sure. And under those scenarios, wouldn't parties have the ability to file something to either challenge recovery or to modify the recovery amount?
When you parties in the case of a rate case, future rate case,
at any point where a party's trying or a utility is trying to get recovery from a regulatory liability or asset.
I would agree with that.
Okay. And that in essence provides some uncertainty on the outcome of those monies, correct?
That's correct.
Okay. And so if there is inclusion of such accounting mechanisms, there's already a level of uncertainty in both Evergy's proposals, correct?
Fair to say, yes.
I want to turn your attention now to the minimum bill. This wasn't necessarily directed towards Kerr, but in response to Mr. Gillum's testimony regarding his conclusion that the minimum bill option would be regressive, you respond that all rate design on some level is regressive, correct?
Yeah, I think that anytime you've got a fixed component, the result will be a regressivity.
Okay. And in your opinion, are all rate designs equally regressive?
No.
Okay. Would implementing a minimum bill to Evergy's residential rate structure, would that make it more or less regressive than it is today without the demand charge, for example, without as a two-part rate by itself?
Well, I think if you're going to increase the fixed component of it for some customers, that would increase the regressivity.
Thank you. I have no further questions.
Thank you. Mr. Bender with CEP Sierra Club Vote Solar.
No questions. Thank you.
Staff, Ms. Massentine.
Commission staff has no questions.
Thank you. Redirect. Ms. Cunningham.
Give me just one sec here. I just have one question on redirect for you, Mr. Shepherd. You recall that Mr. Robert Vincent, on behalf of KIC, asked you some questions about your testimony on page 6 with regard to your analogy or example of, let's see, KSA related to 79 and 3603. Do you recall those questions?
I do. Mm-hmm.
Okay. Would you just please briefly describe the purpose of your testimony there and why you included that reference to KSA 79 3603?
Oh, sure. So I think, initially the thought was that there were comments or testimony that it wasn't a serious proposal if it amounted to a $0 charge. And my point was that there are instances, although the sales tax is not related to the electric use here, but there are instances where policymakers have implemented a method where a charge could equal $0, and it was a serious proposal.
So you're not trying to equate that type of tax with this utility service. Am I understanding that correctly?
No, I think I was just trying to draw a parallel that some policymakers have used that approach.
Okay, thank you. And I have no further questions.
Thank you. On recross, Pioneer, Ms. Caper.
No, nothing.
Thank you. Liberty Empire, Mr. Flaherty.
No questions. Thank you.
KIC, Mr. Benz.
No questions. Thank you.
Curb, Mr. Astrap.
No questions.
And Mr. Bender with CEP Sierra Vote Solar.
No questions. Thank you.
And staff.
No questions. Thank you.
Commissioners, I'll start with Commissioner Keen
No questions. Thank you.
and Commissioner French.
I remain questionless.
Okay, thank you. I believe that concludes our need for you, Mr. Shepherd. Thank you very much. I appreciate your attendance today.
You're welcome.
Your testimony.
Thank you.
Okay, it is 10:42. Why don't we take a 5-minute break and we will come back and start with witness Brian Kalsick. So 10:42, we'll be back at 10:47. Thank you, everyone. It is 10:47 and we are back on the record.
There he is.
We will begin with witness Brian Kalsick. And I believe Mr. Astrab, this is your witness.
It is, thank you. Oops, sorry.
Yes, Ms. Smith. Could you swear in the witness, please?
Please raise your right hand. Do you solemnly swear that the testimony you're about to give and the cause now pending will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you. Please state your name and your business address for the record.
Yes, Brian Kalsick, Kalcic. Business address is 225 South Merrimack, Meramec Avenue, St. Louis, Missouri, 63105.
And who do you work for and in what capacity?
I am principal of Excel Consulting, self-employed.
Thank you. And in your capacity there, did you cause to be pre-filed about 17 pages of direct testimony in response to Evergy's proposal in this docket on behalf of CURB?
I did.
And after that, did you cause to be pre-filed about 12 pages of cross-answering testimony on behalf of CURB in this docket?
I did.
Okay. And today, do you have any changes or corrections to make to either of these testimonies?
No.
And if I were to ask you all the same questions in these testimonies, would your answers be the same or substantially similar?
Yes, they would.
Chair, at this time, I would move to have Mr. Kalsick's direct and cross-answering testimony be admitted into the record.
Is there any opposition? Seeing none, it is so ordered. Thank you.
Thank you. And at this time, I would tender Mr. Kalsick for cross-examination.
Very good. We will begin with CEP Sierra Club Vote Solar, Mr. Bender.
Chair, this is Sunil Vector with Sierra Club. I have a few questions for the witness.
Please, go ahead.
Good morning, Mr. Kalsick.
Morning.
Did you review the rebuttal testimony of Mr. Lutz, which in part responded to your direct testimony in this case?
I did.
Do you have access to Mr. Lutz's rebuttal right now?
I believe so, if you give me a moment.
Sure.
One more moment. Okay, I have it.
Great. Could you please reference pages 18 to 19 of the Lutz rebuttal and let me know when you're there?
I'm there.
So in the last paragraph on page 18 of his rebuttal testimony, Mr. Lutz discusses third-party studies, which is a topic that arose during the public hearing in this case. Do you see that?
I do.
Could you please read aloud what Mr. Lutz says starting on page 18, line 16 through page 19, line 2?
Yes. As for the call of a third-party study, these requests ignore the work done by this commission in multiple dockets, including the 16403 docket. The commission, the staff, and CURB all provide oversight on company costs and associated rate making. A third party does not bring anything new to the table. If the call for a third-party study is an effort to incorporate external values to the cost study, this issue has been considered and addressed by the commission. In the 16403 docket, the commission found that, quote, a value of resource study,
i.e. cost benefit analysis, is not required by the commission at this time because, as testified by staff, such studies have limited value because they return wildly varying results and unnecessarily duplicate information already part of a utility-specific class cost of service studies.
Thank you, Mr. Kalsick. Would it be fair to say that you do not agree that value of resource studies, also known as cost benefit analyses, have limited value because they duplicate information already part of class cost of service studies?
I believe the best way to answer that is CURB address the issue of determining the cost of serving DG customers in the 403 docket. And it was CURB's position, I was one of the witnesses for CURB, that the quantifiable avoided costs associated with serving DG customers should be provided as a credit to the DG class in determining their net cost of service. So if you mean by cost benefit analysis the quantifiable avoided costs, I would agree that such quantifiable costs should be included.
So are you saying that you believe that cost benefit analyses are helpful in the context of residential distributed generation rate design?
Chair Duffy, this is Kathy Dingus. I'm going to object just generally to this line of questioning. My understanding is that Sierra Club and CURB are essentially aligned in their positions, and Mr. Vector seems to be just eliciting, basically direct testimony in support of his position as opposed to performing any kind of true cross-examination. So I don't think this is appropriate.
Your Honor, may I respond?
Yes, please.
So counsel is alleging that Sierra Club and CURB are aligned on this issue, and we don't know if that's true. Neither CURB nor Sierra Club nor any other party except for Evergy filed testimony on this issue. So the concept of third-party studies in this docket first arose in the context of Mr. Lutz's rebuttal. Mr. Lutz cites CURB in the paragraph that Mr. Kalsick just read, and so I want to know what CURB thinks about it.
I will allow it, and yes, continue on and make sure there is a question in your witness examination, please, Mr. Vector.
Okay. Mr. Kalsick, in the context of residential DG rate design, if a utility submits a class cost of service study without an accompanying cost benefit analysis, doesn't that assess the quantifiable net benefits of distributed generation at zero?
I'm sorry, in the end, at zero?
Yes. For the net benefits of quantifiable distributed generation.
So is the question that by not doing a study, a cost benefit study, the assumption is the net benefits are zero? Is that the question?
Yes.
I would agree that the reliance on just a class cost of service study in and of itself does not take into consideration any quantifiable avoided costs associated with DG generation. As to whether the term cost benefit analysis should be used in your question, I believe the cost benefit analysis probably extends beyond the level of quantifiable avoided costs. For instance, in the area of externalities and so forth. And that was not CURB's position in the 403 case. So I would hesitate to say that a full cost benefit study must be done before proceeding to determine the cost of serving DG customers.
Okay, thank you. I have a few questions on Evergy's minimum bill proposal. Mr. Kalsick, are you generally aware that Evergy Kansas Central has an inclining block rate structure in the summertime?
Yes.
And would you agree that a summertime inclining block rate structure helps promote conservation?
I would.
Would you agree that Evergy's minimum bill proposal would undermine the conservation incentive inherent in an inclining block rate structure?
I would agree with that, and that was part of my direct and possibly a part of my cross-answering testimony.
Okay, thank you. Could you please turn to Mr. Lutz's rebuttal testimony at page 6?
One moment. Page 6.
Yeah.
Okay, I am there.
So towards the bottom of the page, and continuing on to page 7, Mr. Lutz is suggesting that Evergy could override minimum bills for low-income customers if those customers identify themselves to Evergy. Do you see that?
I do.
Specifically, Mr. Lutz in his rebuttal at page 6, line 21, says the company could work with customers to override the minimum bill and not apply it to customers who are receiving low-income home energy assistance program funds or other similar bill payment assistance. The company could make provisions for our customer care representatives to override the minimum bill for a predefined time period if the customer would make a request and support their financial need. Do you see that?
Yes.
Based on your experience in the industry, do you foresee any issues with a customer self-identification approach that Mr. Lutz suggests?
Well, CURB first would welcome any relief that the company could implement for low-income customers in the event the minimum bill was adopted by the commission. In terms of whether the self-identifying approach that the company is proposing here would capture all or account for all of the affected low-income customers is problematic in my view. I don't believe that you can rely on simply self-identifying to determine your low-income population, particularly as far as I'm aware, Evergy does not have any existing low-income assistance programs that it administers, and because of that lack of experience there, customers are not likely to be aware of a quote new effort by the company to assist low-income customers, and I would expect there would be a lot of such customers who fall through the cracks.
Okay, thank you, Mr. Kalsick. No further questions.
Thank you. And I apologize. I again have skipped the commission. Commissioner Keen, do you have questions of this witness?
Thank you, Madam Chair. I have no questions of this witness. Thank you.
And Commissioner French, do you have questions?
I do have a couple questions, but I think I'd like to defer them until the parties get through questions. Thank you.
Very good. Thank you. Then we will go on with Evergy, Ms. Dingus.
No questions. Thank you.
Thank you. And Ms. Kafer? None. Thank you. And Mr. Flaherty?
No questions.
Thank you. And Mr. Vincent?
No questions.
Ms. Cunningham?
No questions.
Ms. Massentine? Questions of the witness?
Yes, Chair Duffy, we just have a few questions. Good morning, Mr. Kalsick.
Good morning.
Thank you for your participation in the docket and for being present at this hearing today. Do you have a copy of your cross-answering testimony in front of you, correct?
Yes, I do.
All right. Would you please turn to page 2 of that cross-answering testimony and direct your attention to line 11?
I'm there.
All right. Please read the sentence that begins with "curb continues."
CURB continues to recommend that the commission adopt its interim rate design for Evergy's RSDG customers, which would provide time for legislative action during Evergy's rate moratorium to address existing conflicts in Kansas's statutes regarding DG rate making.
Thank you. Are you aware of whether CURB is proposing to put forth legislation to deal with this in the coming legislative session?
Sure, if you may object real quick, I think that gets into essentially attorney work product regarding what the plans may be in the near future as well.
Chair, if I could respond, Mr. Kalsick in his testimony states that he is aware of CURB's intent to do something along the lines of proposed legislation. So in my mind, he's opened himself up to this line of questioning.
Yes, I'll allow it. Continue on.
I could repeat the question if you'd like, Mr. Kalsick.
I believe the question is, am I aware of whether CURB intends to introduce legislation in the
Yes.
current session and
The upcoming session.
the upcoming session?
Yep.
It's my understanding that they intend to pursue legislation, whether the board has signed off on, CURB's board has signed off on particular legislation. I am not aware of any details.
Okay. So you wouldn't be aware if any, proposed legislation had actually been circulated or anything like that, correct?
Correct.
Okay. And kind of expanding on that, are you aware of any entity currently making concrete legislative efforts on this subject matter? And by concrete, I mean forthcoming bills or other tangible legislative measures.
I have seen no such measures, no.
All right. Thank you. I just have one more subject to touch on. Do you have a copy of your direct testimony in front of you?
Yes.
Okay. On page 6 of your direct testimony, you discuss the minimum bill and go into an analysis of the level the bill would need to be for the company to fully recover the amount of the subsidy, which would be $77. Is that correct?
I don't see $77 on page 6, but I know that begins on page 7, I believe. Yes.
Oh, excuse me. I'm sorry. But $77 is the amount that the company has stated would recover the subsidy fully.
Let me clarify. The $77 was the amount, the average monthly cost to serve standard residential service customers in the company's 2018 rate case. And that average cost was used as a proxy for the cost to serve a DG customer in the company's analysis, both in the 2018 case to facilitate the development of a demand charge, a 3-part demand rate for DG customers, and also as a starting point for the company's primary proposal in this proceeding to implement a $3 grid access fee.
But the company has not proposed for the minimum bill to be $77, has it?
No, not at this time.
Has anyone in this docket proposed a $77 minimum bill?
No,
The minimum bill is set at $35, correct? Or the proposal is set at 35.
proposal is set at $35 in order to introduce gradualism into the minimum bill proposal.
Right.
I believe Mr. Lutz indicated in testifying yesterday that the company was not prepared to state that it would never seek an increase in that level should it be approved.
Right. And Mr. Lutz was also clear about how we don't know what the future holds or what a future rate case could lead to, which is true. But in this docket specifically, the option that we're looking at in regards to the minimum bill, the proposal currently is $35, not $77, correct?
Correct.
Okay. And looking at that $35 amount, if you were to subtract out the current customer charge of $14.50, the maximum impact a customer would see from the minimum bill would then be $20.50, correct?
Yes.
Okay. Thank you for your time, Mr. Kalsick. I do not have any further questions.
Thank you, Ms. Massentine. I turn to commissioners again. Commissioner French? And do you have questions?
I do have a couple questions. I'd like to explore just a couple comments that you had made. First of all, good morning, Mr. Kalsick. Good to see you again. I think you made a comment in speaking with Mr. Bechter that the minimum bill concept would undermine the inclining block rate. My understanding of the Evergy Kansas Central residential tariffs is that for residential customers in the summer months, I don't think the inclining block starts until about 900 kWh. Is that your understanding?
That's my general recollection also, that it'd be 900 and above.
And we've talked about the fact that the minimum bill, it really only represents about 278 or somewhere in that range of kilowatt hour usage. Is that correct?
At this time, it does, right.
So I guess what I'm wondering is, that amount of usage really only covers just a portion of that first block. It never even gets you into the second, the next higher price block. I guess the question is, could you explain more to me on how it undermines the inclining block rate when the customer's not even getting into that next block?
Yes, I should make clear that implementing a minimum bill of $35 at this time doesn't change any of the company's other existing residential tariff charges. So in talking about the impact of a minimum bill on conservation incentives, one has to look to the next opportunity when rates would be changed and how a minimum bill in the next rate case may affect the company's other charges, okay? So if we just pretend that the minimum bill of $35 went into effect in the last case, okay, that would generate some additional revenues compared to the status quo. The company would then have had to adjust one or more other residential charges in order to hit the rate design target in the last case. They don't just get to keep the money. So something else, this balloon that you're working with has to be adjusted. So
If I could, I don't mean to cut you off, but just to understand, you say it would generate additional charges,
additional
revenue. And I guess I don't fully understand that, because in my mind, it would be designed to generate the same amount of revenue. You would just have more certainty of recovering that portion. And I guess in my mind, the revenue might be less sensitive to things like weather. Am I thinking about that correctly, or does it actually produce more revenue?
Let's go. Yeah, I see your difficulty. Maybe the best way to go about it. Let me try again the hypothetical. We're in the last case. And the last case wasn't decided as it was, but the commission decided to implement a $35 residential minimum bill in the last case. First question is, how would that minimum bill in the last case have affected any of the remaining charges that appear today on the residential tariff? When I say that the minimum bill generates additional revenue, I mean that because customers who would normally have had bills, because bills that would normally have been less than $35 would now be $35, any delta is money that you have to keep track of. And now
I got you.
The residential class is supposed to generate $100 million. So now we're getting this much out of the minimum bill and these other charges. We've hit our 100 million and some other charge has to go down. And
so, okay, I think I'm following you. That the volumetric charges is going to go down slightly when you're recovering a little more through a minimum bill. I guess I'm still not following why that undermines the inclining block, other than just the concept that as prices decrease, people's conservation incentive decreases.
To be fair, I guess it in the context of $35 as opposed to 77. The money could be made up for in something other than the inclining, the tail block, the above 900. But if you think about it, if you lower the first block charge, what you end up with is a lower first 0 to 900 rate, which means the minimum bill of 35 now extends beyond 278 because it takes more kilowatt hours to generate $35. So now you're affecting more bills than you would have before. All can be worked out kind of iteratively, but the simplest way to think of it is you have more money that has to be given back in the rate design somewhere else. And
Gotcha.
the easiest way to give it back without affecting that break-even level is to do it in something beyond the threshold. It's a whole other question about what happens if you tried to implement a minimum bill to capture the average cost of $77 to
yeah, for sure.
It becomes orders of magnitude greater impacts.
I'm not proposing that, so I don't think we need to go there. But it does sound like it is just something we need to keep an eye on. If we were to approve a minimum bill, we need to think carefully about how we could preserve the conservation incentive if that is important to us. You would agree with that?
I would agree with that, yes.
Okay. The only other question I have, because you are here on behalf of CURB, I want to ask you the same question I asked I believe I asked it of Mr. Mackey. If we were to go down the road of a minimum bill, I would be curious whether in your consulting experience with other entities and in other states, you are aware of any best practices of protecting low-income customers in a minimum bill scenario. I think you've indicated that let's see, I wrote it down, that a minimum bill is problematic. And I'm not a big fan of that phrase because it can be broad, but I will say you qualified why you think it's problematic. But I would just appreciate any expertise you can lend us on more effective ways to protect those customers, because I can tell you that would be very important to me if we were to go down that road.
Unfortunately, if we're talking about a low income, unfortunately, I don't have any suggestions from other jurisdictions. In my experience, utilities who are best able to address those problems have already identified the population of low-income customers because they have had for years programs that assist low-income customers in paying their utility bills. And in doing that, they've had these customers be identified, incomes verified. This whole infrastructure process has been built up over time. And it takes some time to do that. Many of them are run by third-party administrators to facilitate that because, as Mr. Lutz indicated, the company does not, in its billing system, need to know income status in order to apply a bill, so they don't have it. So it would be, in my mind, a learning curve that would be required, and it might be very difficult at the beginning of that curve to expect to have captured the population.
So in your mind, if we were to go down the road of a minimum bill solution, something like an exemption or an opt-out for low-income folks would at best be a stopgap solution, and you think a better solution or a more holistic solution is to look at low-income assistance programs to specifically target that assistance. Is that, I don't, I'm not trying to mischaracterize.
That'd be fair because you have to get to the point where a utility was as familiar with its low-income population as one that had a low-income program. In my mind, that's the only way you're going to get to that point.
All right. I really appreciate your very candid answers, Mr. Kalsick. That's all I have.
Thank you, Commissioner.
Thank you, Commissioner French. If we could now turn to Curb for redirect. Mr. Astrap?
Yes, thank you. Real briefly. Mr. Kalsick, in regards to the minimum bill discussion you had earlier with Ms. Mazantine, you were present during Mr. Lutz's testimony. You were able to hear on that, right?
Yes, I did listen in yesterday.
Okay. And in that testimony, Mr. Lutz did not acknowledge that Evergy had some sort of cap or limit it was willing to stop at regarding the minimum bill.
Correct.
In fact, Mr. Lutz even admitted that the $77 listed in the testimony may not even be the ultimate full cost recovery for them, correct?
Yes, that was the number used in the last case. Yeah, yes.
Right. And so is it your understanding that that number could possibly go higher in the future in order to capture costs?
Yes, it could very well.
And as far as the subsidy goes, Mr. Kalsick, does the subsidy get worse or better as more and more DG customers get onto the grid?
The aggregate subsidy, assuming that the cost of service used, the methods used to determine the cost of serving DG customers don't change, the aggregate would go up with more customers.
Okay, thank you. I want to turn now to your conversations and the questions you had from Commissioner French regarding best practices, okay?
Okay.
You mentioned something about third-party agencies, like helping run low-income programs.
Yes.
Are these like in reference to like government agencies or private entities or both?
I would say they're probably private but nonprofits.
Okay.
They might be running other utility programs, dollar energy programs, where customers voluntarily contribute $1 on every bill, and that money goes into a pot and then it's distributed and so forth.
Sure.
They have more experience and expertise in dealing with low income, or in some cases, low income issues,
okay,
like income verification and so forth.
Sure. And are you aware through your practice of any other jurisdictions that have government agencies assigned to run these low income programs? Or any kind of low income assistance for that matter?
Government agencies, there's government programs like LIHEAP
Sure.
As to whether the administration is a government agency, I can't say one way or the other.
Sure. But programs like LIHEAP and other like financial assistance programs that are conducted by the government would be created through the legislature usually?
I would imagine so as a starting point, yes.
Great. Thank you. I have no further questions.
Thank you, Mr. Astrab. We turn back to Mr. Bechter for recross.
No questions, Chair.
And Ms. Dingus,
No questions, thank you.
Mr. Flaherty.
No questions. Thank you.
I'm sorry, I missed Ms. Kafer. Okay, no questions, thank you. And Mr. Vincent
No questions. Thank you.
and Ms. Cunningham.
No questions.
Thank you. And Ms. Massentine.
No questions. Thank you.
Commissioners, Commissioner Keen.
I appreciate Mr. Kalsick's testimony. Thank you very much for that, Brian. I have no questions.
Thank you. Mr. French, any more questions? All right, thank you. I believe that does conclude our questions for you, Mr. Kalsick. Thank you very much. We appreciate it.
Thank you, Madam Chair.
Okay, at this time, Brian, are you aware if our witness has returned and is available?
I don't know. We could we can check with Ms. Kafer and see.
Is Mr. Mackey, has Mr. Mackey returned?
No, he has not checked back in yet.
Okay, all right. Just thought we would check before we moved on. All right. I think what we'll do is, why don't we proceed with Mr. Gilliam, if that would be okay, and then probably break for lunch. So, Mr. Bender, I don't see your witness. There he is. Could we swear the witness in, Ms. Smith?
Yes. Sir, if you could raise your right hand, do you solemnly swear that the testimony you're about to give in the cause now pending will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Mr. Bender.
Thank you. Good morning, Mr. Gilliam. Could you state your name for the record?
My name is Rick Gilliam.
And by whom are you employed?
I'm employed by Vote Solar.
And did you cause to be filed in this docket 37 pages of responsive testimony with 2 exhibits and 18 pages of cross-answering testimony.
Yes, I did.
Do you have any corrections to make to that testimony?
I have 2 corrections to my direct testimony. The first one is on page 8. It's part of figure 1, as has been pointed out. The number in the 3rd column on the line labeled grid access charge is $15. It should be $24. That's 8 kilowatts times a $3 grid access charge. The rest of the numbers are correct. The second one is on page 30. Also of my direct. On line 8, the word hour, O-U-R, should be out, O-U-T.
With those corrections made, are your testimonies true and correct to the best of your knowledge?
Yes, they are.
And if I were to ask you the same questions today as appear in the testimony, would your answers remain the same?
Yes.
You would move for these 2 pieces of testimony with 2 exhibits be admitted and the witness is available for cross.
Or is there any objection? Seeing none, it is so ordered. Thank you. So we will begin with the commissioners. Commissioner Keen, questions for the witness?
Yes, thank you, Madam Chair. Good morning, Mr. Gilliam.
Morning, Commissioner.
The first question I want to ask you is the 3-part question that I asked of Mr. Lutz yesterday. And I'm going to ask that question to you in fairness to you, because I sense from your pre-filed testimony and from your other testimony that you may disagree. And I want to give you an opportunity to address the same question. That question is this: within the context of residential electric rates, if solar and non-solar customers pay identical rates, in your opinion, is there the potential for an economic free rider or subsidy problem? That's the first part. The second part of that is that if you believe there is not, or if there is, please explain why you hold that belief. And the third part of that question was, in your opinion, did the Supreme Court in this instance, did it or did it not acknowledge the existence of this circumstance?
To your first question, as I understand it, you're asking if the rates are identical for RSDG customers and RS customers, is there a, quote, free rider problem? And I take that to mean that, is there a subsidy of some sort? And my answer would be no.
That was the question. Yeah.
Okay. My answer would be no. If the rates are identical, and when I say rates, what I'm referring to is the rate for the RSDG customers is the rate for inflows to that RSDG customer. In technical terms, it's channel 1 of the meter. But that's what the load would be. That's where the load would be measured and what the rates would be applied to. So the answer is no.
And with regard to the Supreme Court opinion, what is your opinion about whether or not it acknowledges the existence or non-existence of a free rider problem?
As I read the Supreme Court decision as a non-lawyer, I do not believe the Supreme Court acknowledged the free rider problem when it comes to distributed generation customers. they talked about it a number of times. Each time they referred to it as the utilities alleging such a problem. But the Supreme Court itself did not find that there's a free rider problem.
Okay. Let's move into a little different area of inquiry then. Is it fair to state that given the current technology, reliance upon solar power for residential electricity needs is in essence reliance upon an intermittent source of power where 24/7, 365 reliability is not assured?
And if I can just clarify your question, Commissioner, you're referring to a rooftop solar system, for instance, on a home, not a utility scale system. And you're assuming a rooftop solar system without storage. Is that also correct?
You can assume with or without, but I am focusing strictly, certainly on the residential circumstance. That's correct.
Well, certainly, yes. I mean, the sun doesn't shine at night, and clearly solar is an intermittent resource, but it's a pretty predictable intermittent resource as well. So if you add storage to it, you can you can take your home off grid if you so choose.
And with current technology, kind of explain to us, if you would, what the scope of that storage capability is currently.
Well, it's fairly straightforward today to go out and purchase the Tesla Powerwall storage systems. Those are just examples. There are other types on the market as well, but you would generate power during the day, store that power that's in excess of your needs, and use it at night.
And for what protracted period of need would that be available, generally speaking?
It's hard to say that there's a specific period. It depends on how much storage that the customer has.
Okay. Follow me along here. I'm going to lead to a point because I want to get your take on the essence of why we're here. So if solar is intermittent for the reasons you've indicated, it would stand to reason, does it not, that it would need to be backed up by non-intermittent sources if the system is to have uninterrupted service?
When solar is deployed on a residential premise, there are times when the solar is generating, as you were alluding to, and times when it's not. When it's not, it's known that it will not be. But there's some important points to be aware of there. One is for at least for Evergy, when their system peaks occur, which is the basis for planning and building their generation system, which is the majority of the costs of Evergy. Solar is generating, and as Dr. Faruqi's testimony showed, the load placed on the system at those times is low, if not zero, and sometimes negative. So in terms of cost causation, yes, there will be times when the utility needs to provide power to the customer because the solar system is not generating, but the solar system is also not causing any costs to be incurred on the utility. So in the other example where there may be, say, some dark clouds that come over a system during the day, and the system then the power is reduced from that system, the amount of additional service that's required from the utility is about the same as certain appliances being turned on or plugging an electric vehicle in. And at least what I've seen in Kansas is that there are more electric vehicles in the state than there are solar systems. I hope that answers your question.
No, I appreciate your answers. Isn't the ultimate question that's before us under this remand, by whom and how are the utilities fixed costs associated with providing residential service reliability to be borne? Is that one way of characterizing what's before us today? Is that a fair characterization?
I think I would go beyond that characterization, if you will. The quote subsidy that has been alluded to many times in this proceeding and is characterized in the grid access charge calculation that Dr. Faruqi performed and is, I think, in the record as Sierra Club 1. There's another more extensive determination shown in a response to discovery we got that is now in the record as Sierra Club 3. That shows that the settlement revenue, well, let me back up a second. That's been the basis for discussion of the so-called subsidy. But that subsidy is based on what was the original cost of service of Evergy for the DG class, and then subtracts from that a level of revenue, and both of those figures are actually incorrect. When we look at the subsidy in the DG class, what we should be looking at is not what Evergy had asked for, what they felt was the total cost of service, but what the settlement approved as the proper level of revenues for the DG class to contribute to the system. And that's in Sierra Club 3. That number is, and I'm just going to use generalities here, that number is about $165,000. The revenue that is collected under that would I estimate to be collected under the current two-part rate would be pretty much that amount. It's about $1,000 or $2,000 less than that, as I recall. So essentially, there is no subsidy, and that's why I said that in my testimony. So the important thing to remember here is that the difference, the subsidy that is being claimed is the difference between the revenues that are being collected and what Evergy would like the cost of service, would like to collect under the full cost of service as submitted to the commission in the original portion of this docket. If we look at a similar determination for the general body of residential customers, the original target cost of service for the residential class was $25 million higher than the amount of revenue provided at that time during the rate case. The settlement reduced that revenue by another 20 million. So one could say that the subsidy that's claimed by Evergy for DG customers is on an equivalent basis for the residential class would be $70 million, well over 1,000 times what the claimed subsidy is. So I have a hard time accepting the fact that there's a subsidy at all in this case to deal with. The issue in this case is discrimination. The two services being provided are essentially the same, the service to DG customers as far as inflows go, and the service to residential customers. They are the same. The Supreme Court effectively said they were the same too. They recognized that DG customers can export. So given that, my answer to your question is no, there is not a subsidy. And the purpose of this case is to develop a rate or rates or strategy for assuring that there's no discrimination.
I appreciate the articulate and nuanced response. But in essence, it comes down to some fixed cost determinations too, does it not?
I'm sorry, I didn't catch the
allocation of fixed costs. I'm sorry, I interrupted you.
I'm sorry, yes. It's allocation of fixed costs to all customer classes. DG is no different than the residential class. Because there's a lower revenue contribution in the DG class towards those fixed costs, doesn't mean that there's not also a lower revenue contribution towards fixed costs in the residential class. The point is that the revenues are collecting what the settlement indicated that they should collect.
Let me turn to my last line of questioning here to your reply comments. That's what I'd like to focus on a bit if we can. And again, I'm gonna generalize a bit to get to the cut to the chase of the essence of the question I would like to have you answer. If I misstate the question in some way, please don't hesitate to correct it. As I understand your argument here, you're arguing that any rate design, as I see it, that the commission orders to replace this three-part residential DG rate must charge DG customers the same rates that would apply if they did not have renewable generation. Because as I understand your position, any new charge that's imposed only upon DG customers would violate KSA 66-117D and the court's holding. Could you give me your take on that, and with some level of detail, if that is your conclusion, can you give us some summary of why that's the case?
Yes, and to be fair, there could be other rate designs that that would not be seen as discriminatory. The challenge I think we have here is that the goal of Evergy is to collect that, what I refer to as a so-called subsidy. And any rate, any structure that is developed that ends up charging distributed generation customers that much more so that those customers pay another, whatever it is, $80,000, $40,000, is going to be discriminatory because non-DG customers don't have to pay that cost. And so, so the answer to your question is, now technically there could be another rate design that would not be discriminatory, but I don't think it's something that Evergy would support because their goal, again, is to collect that so-called subsidy. I hope that's helpful.
Thank you, Mr. Gilliam. I appreciate your answers very much. I have no further questions at this time.
Thank you, Commissioner Keen. Commissioner French.
Thank you. Good morning still, Mr. Gilliam.
Good morning.
I was gonna defer my questioning, but there were a couple answers that maybe I didn't completely understand there, and so I didn't want to forget to ask this. So I'm gonna start this question with sort of a long preface, and this preface reflects my understanding, but feel free to disagree in your answer if you disagree with my preface. The preface is this. So I think that most of us who have been around utility and energy issues, rate making issues for any length of time understand that when we pay our utility bills, we are primarily not paying for electrons. We are paying for the machine. We're paying for the poles, the wires, the power plants, the fixed costs of the system. Whether you're solar or non-solar, you're paying for energy to be available to you on demand whenever you flick the switch. And so the confusion I have is, I believe in response to one of Commissioner Keene's questions, you said that DG customers are not causing any costs to be incurred on the utility when they are not importing energy from the utility. And doesn't the fact that these customers are asking the utility to have the grid available to them at all times mean that they are also causing costs, fixed utility costs, to be incurred at all times when they are connected to the grid?
Okay, the part of your question that I wanted to clarify is when you say these customers, do you mean customers generally, or do you mean DG customers?
Distributed generation customers specifically. Okay.
That's a good and very important question. And the way I would answer that is that the answer is customers do expect the power to be there when they turn the switch on. The same is true for all residential customers and all customers in general. But the comparison with residential is really what's important here. And I think the idea that a DG customer that maybe has a peak load at night or at some other time during the day is causing costs is an important clarification that we need to make. And if you look through my testimony, or if I don't know if you were a commissioner during the original part of this case, but in Mr. Amen's testimony for the company, he describes how they assign costs to the different customer classes. And that cost allocation process is based upon cost causation. So what the utility does is they look at the critical times that they need to be able to serve customers. And those in Kansas are typically the summer peak periods, which are the 4 summer months, and the peak periods typically happen 4 o'clock, 5 o'clock in the afternoon. So while it's important for a customer that has a peak at 10 o'clock at night to have that infrastructure there, they are not causing that cost because the company has to build that to meet the peak at the peak hour, which is much earlier in the day. So essentially what is happening is that the customer is using excess capacity or unused capacity, however you wanted to think about it at that point in time. Now that's, I said that the 4CP, or the 4 coincident peak, is the basis for allocation. In Evergy's case, there's actually a second basis, and it's roughly 50-50 on how these are weighted. The other basis is energy. So there is an energy basis for allocation of production costs. And to the extent that that is part of the overall allocation process, DG customers receive that a share based on their energy consumption as a class, not as individual customers. Remember, these rates are designed for the entire class, not individual customers.
So if I could cut to the chase, it sounds to me that you are saying, at least allegedly, distributed generation customers are not using the system during the peak demand time, which the system is planned for, and thus should not be allocated any portion or any material portion of those fixed costs.
That's correct. Well, but let me just add that there is a portion that's allocated to customer classes based on energy use. And so there was a statement by Dr. Faruqi, I think, that energy use goes down and costs don't go down. But because a portion of energy of allocation is based on energy, as the DG customers' energy use goes down, their cost responsibility indeed actually does go down. So, the customers are contributing the appropriate amount if the allocation process is done in that fashion.
Okay. Let's move on from that question, and I want to give you the opportunity to address a question that I think I brought to Mr. Lutz yesterday, and I guess I would like Sierra Club's position on this, and I'm going to share my screen briefly. All right. Can you see PDF document with highlighting?
Yes.
This is the Supreme Court opinion. It's the same passages I discussed with Mr. Lutz yesterday. In this first portion, the court recognizes they recognize the subsidy or the alleged subsidy. I won't force you to say whether the court agrees or disagrees that there's a subsidy, but they recognize the argument of a subsidy. And then in this next paragraph, the court says, and I'm paraphrasing, they can move past the subsidy issue with relative ease because the policy of favoring customers who generate a portion of their own energy from renewable sources was chosen by the policymakers in the legislature as it is cemented in Kansas law. The court makes a point to say that they aren't going to say whether that's good or bad policy, but that their interpretation is that's the policy of the state of Kansas. Is it Sierra Club's position that there is no subsidy, or is it Sierra Club's position that whatever subsidy there is the policy of the state of Kansas, and it would be unlawful for us to remedy that that subsidy, or is it both?
Well, I think it's complicated. What the Supreme Court is referencing here, I would say, is a more generic view of subsidy. And if I might describe that as all customer classes are contributing the full cost of service, and the rates are designed based on that full cost of service. And this is when, well, I'm sorry, let me just continue. The reduction in use by DG customers, which, as the court has said, is a feature of volumetric rates, I would say in theory does create a subsidy. And I believe this is what the court was referring to. But that subsidy is the same for any customer that uses less than they did when the rates were first designed. And of course, most customers are trying to do just that, use less so they don't have to pay as high a bill. So I think the situation in the case we're in today is that we have a settlement agreement that doesn't recover the full cost of service as set forth by the company in 2018 for either DG or for residential customers. So what we're trying to nuance here is whether or not the full cost of service for DG customers constitutes, and the difference, the shortfall of the revenue collection constitutes a subsidy any more than the equivalent numbers for the residential class. So I think what the court is saying is that there may be reductions in use, but for DG customers, but that is what is cemented in law, that the rates cannot discriminate between customer based on the use of distributed generation by residential customers.
Okay.
I hope that's a long-winded answer. I hope I got to the heart of your question.
No, it's a good answer, and I will just say I think I said this before, but I struggle with that passage from the opinion. The opinion says a lot of things, and it is sometimes difficult to reconcile what different passages throughout that opinion say, and the significance or broadness we should attach to any one particular passage. So I appreciate your thoughts on it. To the extent I have more questions, I'm going to reserve them until after the parties go through their questions. Thank you, Chair. Thank you, Mr. Gilliam.
Thank you.
Thank you. And I'll reserve mine as well. Mr. Gilliam, please, let's see, Curb, I believe. Mr. Astrap, you're first up.
Yes. Curb has
Okay.
no questions at this time.
Okay. And Ms. Dingus with Evergy.
No questions, thank you.
Pioneer, Southern Pioneer.
Yes, thank you. Just a threshold question, Mr. Gilliam. Does Sierra Club agree that the statute we've been talking about, 66-117D, applies to renewable DG only and not non-renewable DG resources?
As a non-lawyer, that's how I read it.
In the initial, you were involved in the comments that were filed by the Sierra Club group, correct?
Yes.
And in those initial comments on page 11 and 12, you cite to 3 reports that were published by the Regulatory Assistance Project. I believe it was in the context of supporting your objection to the straight fixed variable rate design, correct?
Correct.
And can I refer to Regulatory Assistance Project as RAP?
It works for me.
Okay. Can we assume that you believe that RAP is a reliable scholarly publication since you've cited to it repeatedly for authority for your in support of your positions?
Yes.
I'm going to put on my screen here. Oh, geez, I got it here somewhere. This is a RAP report that was cited to by Southern's and Pioneer's witness, Mr. Mackey, standby rates for combined heat and power systems. Are you familiar with this report by RAP?
I'm not familiar with it, no.
Did you read Mr. Mackey's testimony?
I did.
On page, I'm technology, this isn't how we've done it. So on page 4 here, the executive summary of this RAP report, I've highlighted to help us look at it here, but this is where the report indicates that standby or partial requirement service is a set of retail products for customers who operate their own generation on site. And that these standby rates cover certain services. Are you with me here on this?
Yeah.
And they list out what those products or services are that the utility provides. And if you've been around, this might look familiar because this was reflected in Southern Pioneer and Pioneer's PowerPoint that has now, or page 3 that has now been made an exhibit in the proceeding because, and there've been a number of questions asked about it. Let me ask you some questions. I would also point out this is the executive summary, but this is also addressed later on page 8 in more specifics of the report. Does the availability of these services that are listed, does that benefit distributed generation customers?
Well, I guess first I would point out that this report relates to combined heat and power. Combined heat and power systems are typically found on industrial customers, very large customers. And standby service for large customers such as those is a very different animal to a utility than a rooftop solar system is to a utility. And the reason I say that is essentially it's a matter of scale. Large systems need to be planned for by the utility because if they are not available, then utility may have a significant load that it has to serve that it is not necessarily prepared for. So in that context, then these services make sense. And also, well, I'll stop there.
So you're saying, and I agree with you, the Supreme Court in this case wasn't talking about commercial industrial, it was talking about residential. But are you then saying that these types of services or products are not used by residential DG customers?
I would frame it a little differently. I would frame it that these products and services are inherent in the basic service provided to all residential customers, including distributed generation customers, because basically because the size of the DG systems are typically the size of other loads that the customer has, that the utility serves all day long and all year long.
And if you hadn't looked at this, why did you think this was only addressing combined heat and power applications?
Well, because you showed it to me when you first put it on the screen.
Okay.
But I think more generally, if I can add on to that, standby rates and the types of services listed here are usually found on large customers or large customer tariffs. And not just large retail customers, but they're also common for large wholesale, not large, but wholesale customers generally. Because wholesale customers often have other sources of generation besides a single supplier. So in those cases, the utility that's providing those services does have to plan. It does impact the generation that it must keep online. It may have spinning reserves at a different level. It may have overall reserves, planning reserves at a different level as well, depending on how much additional power it may be needed if that customer's combined heat and power system or backup generation, whatever generation they have on site, becomes unavailable. It's very different.
Can a residential distributed generation customer with solar power, can they really have that arrangement for themselves if they don't have these services or products available from the utility?
I'm not sure I understand your question. Could you rephrase it?
You said that these really aren't applicable to residential solar power customer generators, but can they have, can they engage themselves and have their solar power rooftop generation if they don't have these services to back them up?
Well, I think what I said was that these services are inherent in the service that's already being provided.
Well, as a non-DG customer, you don't have unplanned generation outages, do you? Because you don't have generation of your own.
No, but you don't price out these services unless you have a cost associated with that backup power that's in addition to what your normal service is, if you understand what I mean.
Well, I understand you go back to cost frequently, and I'm really not asking you about cost. I'm asking you about the benefits that your DG customers receive, and they get those benefits as a DG customer because they have these services backing them up from the utility, correct?
My point is that the services are not any different from the services that are provided to non-DG residential customers.
And that is then back to my question. As a non-DG customer, I don't need backup power for my unplanned outages because I don't have unplanned outages because I don't have a generator, correct?
No, you don't, but you have maybe an electric vehicle that you plug in that puts 10 kW of load on the system instantaneously.
Can I go ahead and mark this report since I've asked questions on it? Can I go ahead and mark it as Pioneer Exhibit number 3 and move for its admission, please?
Is there any objection? Seeing none, it is so ordered. Thank you.
I'll bring it down here. I'm still kind of slow at this. Mr. Gilliam,
can I clarify? Are you marking the entire document? Is that correct? As Exhibit 3? Okay. Just wanted to be sure. Thank you.
Mr. Gilliam, what factors would you think should be taken into consideration in determining whether a service is different from another service?
Well, the nature of the service, that is the load of the customer, the size of the customer. As I showed in my testimony, the residential class is a very broad class with many different types of customers in it. And so there are different subsets of customers within the residential class that could be broken out separately, like the company is trying to do with distributed generation, and priced separately, and the rates would be very different. So the load pattern is, I think, probably the most important thing, because that's what causes costs on the utility.
Okay, most important, there might be other factors that you could look at too, depending upon the facts of the case. Would you agree with that?
There could be other factors, certainly.
Isn't the KCC the ultimate authority that makes the factual findings and proceedings on utilities applications?
Yes.
Let me ask you about the language here that Commissioner French asked you on the this part of the Supreme Court's order where they mentioned favoring DG customers. When you read 66-117D, did you take from that that DG customers are to be favored or that they are to be treated equally with non-DG customers?
I'd say they're to be treated equally.
And if non-DG customers are paying the costs the utility incurs to serve them, does making DG customers pay the cost incurred for serving them in some way prejudice or disadvantage DG customers?
That's my point, that residential customers are not paying the full cost to serve them.
And that's a factual determination. You know, I'm not getting into the cost because that really isn't my question. My question is, if the commission ultimately determines that under certain rate structures, non-DG customers are paying the costs that the utilities incurred to serve them, then would DG customers be prejudiced or disadvantaged if they were required to do the same thing?
Your Honor, I'm going to object to the question as ambiguous and confusing. I understood she's not asking about cost, and I heard cost mentioned several times in the question. I'm not sure, and I'm not sure the witness can fairly answer the way it was phrased.
Ms. Kafer, can you try and rephrase that, please?
Sure. If the commission has made a determination that non-DG customers in their rates are paying the cost the utility incurs to serve them, then does making DG customers pay the cost incurred to serve them somehow prejudiced or disadvantage the DG customer?
Well, let me try it like this. If the DG class is singled out and is required to make up the difference between the revenues they provide and the full cost of service as set forth by the company, and the remaining body of residential customers is not, then I would think that the DG customers are being disadvantaged.
That
Yes.
really isn't an answer to my question, but I will move on. Did Sierra Club appeal the commission's finding that there was a subsidy flowing from the non-DG to the DG customers?
I might want to have our attorneys answer that to be precise.
You don't know if your appeal alleged that the commission's finding of a subsidy was invalid in some way?
My understanding of the appeal is that it was that there was a discriminatory rate imposed. And we were appealing that under 117D.
So based at least upon your understanding of what happened, would you agree that the Supreme Court didn't disturb the commission's finding in its case that there was a subsidy from non-DG to DG customers? If you don't know, that's fine.
Again, as a non-lawyer, I think that's correct. However, they said that even if there is, well, I'm not. I guess, you know, the decision speaks for itself. My view is that the court said that the rates that were being charged, and I guess in your view, that would be to relieve the subsidy, were discriminatory, and that was improper.
Would you agree that the statute 117D doesn't say anything about subsidies?
Yes.
Would you agree that the statute doesn't require the preservation of subsidies for DG that may already be in rates?
Provided it's not discriminatory.
I don't quite know what you mean, but are you saying that if they're going to remove the subsidy for DG, they have to remove the subsidy for everybody?
Well, maybe you could clarify what you mean by subsidies that are already in rates.
Subsidies the commission may find are in rates, and they're the fact finder. So if they find there's a subsidy in rates, there's nothing in the statute that says they can't remove those subsidies from rates, correct?
There's nothing that says the commission can't remove those subsidies?
Correct.
Yeah, that's correct.
Okay. That's all I have. Thank you.
Thank you, Ms. Caper. We should move now to Liberty Empire. Mr. Flaherty.
No questions.
Thank you. Kick, Robert Vincent
No questions, thank you.
and Ms. Cunningham
No questions. Thank you.
and staff. Ms. Messentine.
No questions. Thank you.
Commissioners, do you have additional questions at this point of the witness? And I will start with Commissioner French. None. And Commissioner Keen.
Yes, Madam Chair, I do. Just a few.
Please proceed. Thank you.
All right, thank you. If I could ask, Ms. Kafer, could you once again the Pioneer Exhibit number 1, page 3?
And Ms. Kafer, you are muted. Okay, but you are screen sharing. Thank you.
That's the wrong one. That's the wrong one. Exhibit 1. Your slides.
I believe that's Exhibit 3.
Right.
Get there eventually.
Page 3, please.
There you go. Can you see it?
Thank you, Glenn. Yes, that's it. Thank you. No, that's not it. You had it. Now you have it. Very good. I'm not sure we're paying you enough for this service, Glenda. Thank you.
I'm gonna go take a class.
Okay, Mr. Gilliam, if we might again, can you hear me all right?
Yes, I can.
Were you online this morning during my cross-examination of Mr. Mackey?
Yes.
Do you recall my line of questioning regarding this exhibit 1 and page 3? That is, do you recall my line of questioning of Mr. Mackey of this page 3 of exhibit 1?
Generally.
That's fair enough. Generally, no trick question intended there. As I understand it, in essence, this page 3 of Pioneer Exhibit 1 seeks to summarize, identify, and distinguish certain electric service attributes that differentiate the services provided by a utility to DG customers versus the services provided to to non-DG customers. Generally speaking, is that a fair portrayal of what this exhibit provides?
Yes.
But my question is this. Do the differentiators that are set out in this exhibit accurately represent real or actual differences in the levels of service provided to DG customers and not provided to non-DG customers?
No, they do not. And I tried to be more clear before. Let me try it again, because I'm definitely not being as clear as I need to be. These
I appreciate your indulgence in the question.
Oh, absolutely. These services are inherent in the rates for all customers. We call them services, but really there's not a difference in the nature of the service between residential customers and residential DG customers. The reason that they are shown as services, and in the other document that I looked at with Ms. Kafer, is that when a service is provided, there's a charge for that service, usually because that service results in a cost being incurred. And so for large customers, for wholesale customers, when a significant generator, significantly sized generator, is the only source of power other than what the utility provides, and that generator goes out, then that industrial customer must have some kind of a backup. And they're willing to pay for it because their generator is not operating, so they have to lean on the utility to do that. And from the utility's perspective, it's a significant load, additional load that comes onto its system if that generator is not operating. The utilities typically are planning in some statistical fashion for the generators that industrial customers have to be operating throughout the year, and different contracts are structured differently. But the point is that backup power, the reason it's a service called out like this is because it incurs a cost when the generator is large enough for the utility to have to take it into account. In the case of distributed generation, the generators are no larger than the size of appliances and electric vehicles, for instance. So there's no planning, there's no additional cost necessary for the utility to provide additional energy to the customer if, for instance, when the sun goes down or if the system goes out. And just as a side note, unplanned solar outages are incredibly rare. There's no moving parts, as you probably know, in a solar system. And roughly once every 10 to 15 years, the inverter needs to be replaced. And that's the extent of the maintenance, other than maybe washing the panels. So the utility does not have a cost that it incurs for backup or for maintenance. And the supplemental power is just the normal power that the DG customers receive and that non-DG customers receive. In terms of the nature of the service and the type of load that's being served. If you look at figure 2 in my testimony, it compares the energy use across an entire year and then also across the summer months of DG versus non-DG residential customers. And as you can, and that shows that they are quite similar.
Do you believe that the same line of reasoning would hold or apply if the development of residential solar was to accelerate arithmetically or geometrically, as I think one of our witnesses in these proceedings suggested it might.
I'd like to address that in a couple of different ways. First, as you know, Kansas has some of the smallest amounts of solar of any state in the country, and it's far from having anything that would be consequential to the utility at this point. Colorado has about 50 times the amount of solar, rooftop solar, that Kansas does, and has not run into any of the problems or any of the concerns that are outlined on this slide. The only utility, or the only state that has, to my knowledge, is Hawaii. And they are at a stage of something on the order of 30 to 35%, maybe more by now, of customers with solar. And so it's an enormous part of their system. But of course, in Hawaii, the rates are very, very high, in excess of 20 cents a kilowatt hour. So to answer your question, in the very long run, yes, there is likely to be some need for or some cost incurred by the utility and some need to address very high amounts of distributed solar. But I'm not even sure that will be in my lifetime in the state of Kansas.
All right. If you wish, you could remove the exhibit from the screen. Let me follow, if I might, your last response with this question. In the shorter run, taking us back to something more near term, in its generating planning process, doesn't Evergy have to take into account the variable demands over the course of time, near term, that distributed generation is going to require versus non-distributed generation?
I believe you're asking for the customer classes, the DG class and the non-DG class?
Yes, that's right. Yes, thank you.
The way that utilities take distributed generation into account, in my experience, has been to reduce load by the amount of the distributed generation. And that's often done in the same way that utilities take energy efficiency into account in its resource planning. There's two parts to that. As you know, there's an energy part and a capacity part. And maybe your question is geared more towards the capacity side. And I think Dr. Faruqi had calculated a capacity value for solar, I think it was in Kansas, of 34%, which is a little bit on the low side, but not too much, probably somewhat reasonable. And that's the amount of capacity that the utility can count on from the DG systems that are out there. So in other words, and I don't know off the top of my head what the total megawatts are. I think it's on the order of 5 or 6 or 7 megawatts of distributed generation. 34% of that can be relied upon by the utility for meeting its resource needs. So there's a value to that, to having that capacity on the system. And that's one of the benefits that was discussed earlier today, but is not taken into account in the consideration of, what has been called the subsidy.
Okay, just one, I'm really very close to the end of my questioning here to be sure, but just to make sure I understand. So you're suggesting that Evergy in a planning process wouldn't necessarily have to separate or account for the demand needs that it's going to have from the DG customer class, as opposed to the non-DG or the combined total.
The characteristics of the DG customers are not sufficiently different from the non-DG customers in order to plan for them separately, particularly when there's, and I forget the exact percentage, but an incredibly small percentage of the total is DG. The total residential class is DG.
All right, very good. That concludes my questions. Thank you, Mr. Gilliam.
Thank you.
Thank you, Commissioner Keen. Mr. Gilliam, as you appear to have a very extensive background in solar as a renewable, and you were talking about rate design issues. In a perfect world, what would rate design look like that would include distributed generation, not as an aberration, but as a part of a functioning system?
That's a great question, Chair Duffy. I think the ideal rate design, and this would be for all customers, including distributed generation, is being rolled out across the country as we speak, and that's time of use rates. The big challenge that we have now is that we're using, as has been said before, in volumetric rates as a very, to not overuse it, but a blunt instrument to collect the cost of providing service from the utility. And it does not differ, even inverted block rates do not differentiate the timing of when that load occurs. And as you dive deeper into the costs of providing service, and we've talked about that some today with the summer peaking, those are the times when you want customers to reduce their load. And so those are the times that the rates should be a little bit higher. And there's been a lot of work, some of which Dr. Faruqi has done too, on this issue of how high should those rates be? How many hours should those rates be higher? What should the differential be between the peak periods and the off-peak periods? Should there be a super off-peak period to encourage electric vehicle charging at night? There's a lot of nuances to it, but nevertheless, what time of use rates do is they actually reflect the cost of the utility at the time that you're using energy, which gets away from this whole idea of cross subsidy for any class, and charges customers for what the actual utility cost is. And that also would be, and net metering works in that regime too. But that also would assure that customers like DG customers who don't put load on the system during peak hours get some value for that ability. And would also encourage customers to reduce their usage during those peak hours and increase usage or shift usage to hours when the price is lower. So, there are things that are still challenges with it. I wouldn't say it's perfect, but based on the metering technology that we have available now and the increasing amount of solar and storage technologies that are available and will be available at even lower cost in the future, I think the time of use approach, which, as you know, was mentioned by the Supreme Court, would be the optimum rate design of the future.
Thank you. Are you aware if you talk about metering technology, are you aware if Evergy currently has that metering technology as it relates to residences and residential customers?
The short answer is no. I believe they do for DG customers because, you know, we got the data from them for those. And they also have metering on the customers that they do load research on. But now let me think for a second. No, we got detailed data. A lot of it was missing data, but we did get detailed usage data from several 100,000 residential customers. So I believe Evergy probably does have smart meters on its, or AMI, advanced metering infrastructure, on its residential customers too.
And it's my understanding, and I hope somebody clarifies that for me if I'm wrong, is that this is for the large part of Evergy's population has been put into place, if I'm not mistaken. So I think that's something that we can get clarified later. So as we talk about this time of use, what are you familiar or know of any states who are taking advantage of time of use rate design to better provide a playing field for their customers?
Oh, yes. You know, Dr. Faruqi talked about California some. I live in Colorado, and I'm much more familiar with the time of use rates here. We had a pilot program for a number of years, and just earlier this year had a proceeding that evaluated the results of that pilot program, and we ended up settling among all the parties on a new time of use approach that addresses just the factors that we were talking about a minute ago. There's a 3-hour peak period. Shorter is better. It's easier for customers to deal with. There's what we call a mid-peak period, which is when the costs are still higher for the utility, but not actually a peak for the utility. And then all the rest of the time is off-peak. And those hours are from 7 p.m. to 11 a.m. each weekday, and all hours of the weekends are off-peak periods, which, you know, is great for people who are concerned about, you know, having to wait till midnight to do their laundry or 11 o'clock at night to do their dishes. It's quite, when you get into the cost, and I think most utilities will be roughly in the same ballpark, the costs in the middle of the day are the highest, and in the late afternoon, early evening are the very highest. Once you segregate those out, the costs for the rest of the hours of the day are pretty low.
So in the two states you're familiar with, California and Colorado, was there a hue and outcry by the customers that this time of use applied to, or what has been, have they been in place long enough for you to comment on their applicability and how it's going?
In terms of your first question, there has not been an outcry. And in fact, I mentioned a pilot program. This is in Colorado for the time of use. That took place over a couple of years. So it's roughly 18 to 24 months, ending about a year and a half ago. And there were actually two pilot programs. The company implemented both a demand-based, a 3-part rate, demand-based residential rate, and a time of use residential rate in separate pilot programs. And they received volunteers for gosh, I want to say 3 to 4 times the numbers in the time of use as applied for the demand charge. And they marketed both of the pilot programs equally. So it was, self-selected clearly, but most people self-selected to the time of use rate.
Okay,
And I'm
All
sorry, I
right.
forgot the second part of your question.
that's okay. Yeah, I just wanted to know if there was data to suggest that the intent of the time of use, are we seeing good results that it has accomplished its purpose?
Yes, and I'm thinking back to the data that came out of the pilot program. And I should clarify, the case to develop the long-term time of use rates happened earlier this year. It's going to be rolled out starting in about 2 weeks, on January 1st. It's going to be rolled out. Part of the challenge.
Excuse me, and where is that? That it's
in
going to be
Colorado.
Colorado. Okay.
And the reason for that is because we don't have AMI infrastructure throughout our system here. So the utility is putting it in as we go along. So they're putting it in section by section. It's a 4-year process. And as it's rolled out, customers will be then transitioned to the time of use rate as the default. One important aspect of the time of use rate is to make sure that low-income customers have some way of avoiding the time of use rate if it really doesn't work for them. Many lower income customers work multiple jobs or have medical equipment at home. And for one reason or another, the time of use just simply doesn't work. So it's important to have an opt-out provision in the time of use rate so that customers in that situation can opt out back onto a volumetric rate that works better for them. So that was the only caveat I wanted to mention.
Okay. As it relates to solar and low income, the discussion is centered around, I believe, Dr. Faruqi, that most low income folks can't afford rooftop solar. At one point, at what point what is there a solution, or are you aware of any communities who are trying to bridge that gap with low income?
Yes, probably the most prevalent means of getting solar resources to lower income customers is through community solar. And there was some discussion about that yesterday, but community solar, the term community solar means something very different to me than what was discussed yesterday in Kansas. I would refer to Kansas's or Evergy's program more as a green pricing program than as a community solar program. True community solar will save customers money because the cost of the resource is lower cost than the cost of the utilities resources. A green pricing program simply is a feel-good program that allows customers to pay more to encourage the use or encourage the utility to build more renewable energy. It's not a bad thing, but renewable energy doesn't really need that anymore. Wind and solar costs are way lower than they used to be, and in most cases lower than virtually all new generation resources, fossil fuel generation resources, and lower than many existing fossil fuel resources. But to get back to your question, community solar has been the kind of the program of choice in the states that I work in. And there are usually some type of either carve-outs or specific access allowed for lower income customers to be able to access that community solar and reduce their bills through that vehicle.
Okay, so I've read some articles, so they're talking like a neighborhood and there's a solar array and an apartment complex or an area is effectively receiving the benefit of the solar array directly into the complex. Is that correct? Is that, I know it's very simple, but is that essentially it?
Yeah, that's a simple approach, but there are some programs where the solar is located in another part of the service territory of the utility. It still connects to the distribution system, but generally it's less expensive to build a project out in a rural area where the land costs might be lower and there are just other costs associated with building systems closer into a suburban or urban area.
Okay, very good. Thank you. I believe that's all the questions I have for you at this time. And as it is.
Chair Duffy, may
yeah.
I ask just two brief questions as follow-up to the commissioner questions?
For
Mr. Gilliam.
Oh, okay, please do.
Thank you. Just briefly, Mr. Gilliam, you were talking about time of use rates with the chairwoman. I wanted to clarify, you would agree that a time of use rate is a volumetric rate, correct?
Yes.
And given that if a utility implemented a time of use rate, it would still be recovering its fixed costs through that volumetric charge, correct?
Yes, it would, but it would also.
And I just really wanted a yes or no answer. Thank you, sir.
Your Honor, I think the witness should be allowed to answer fully the question asked.
It was a yes or no question. I think he answered it.
I think he was cut off in his answer.
As I don't believe anybody's just answered a question with yes or no in this proceeding. Mr. Gilliam, please go ahead.
Yes, time of use rates are volumetric, but the critical factor is that they are tied time-wise to the costs of the utility. So the fact that you pay more during higher cost hours does tend to reduce consumption during those hours, but in most cases, that consumption is taken up somewhere else. In other words, customers are shifting the use of their of the electricity to other hours of the day when it's cheaper. Just the same way that people in some states, at least, will change their driving habits to accommodate peak hour pricing on highways.
Thank you.
Thank you.
That's all I have.
Thank you, Ms. Dingus. And at this point in time, I believe it's time for a lunch break. It is 12:50. We are taking a 30-minute lunch break. We will reconvene at 1:20 and begin with redirect. At that point, we will finish witness Gilliam, and then we will return to witness Mackey for any additional questions. So at this time, we are off the record and in a lunch break to reconvene at one.
Just a quick note to the parties to take a look at the chat that the court reporter sent about information that she could use for anybody that's requesting copies of the transcript. So thank you.
We are 1 minute out. Good afternoon. It is 1:20. We are reconvening and we are back on the record. We will begin this afternoon's witness, starting with Mr. Richard Mackey. And I believe as we left, we were ready for Ms. Kafer and her redirect. Is that correct? And I would remind Mr. Mackey that you are still sworn in as a witness. Yes.
Chair Duffy, does it make sense to finish with?
Oh, I'm sorry. Yeah, it does. With
Sorry,
Mr.
I'll do whatever the parties favor, but I think it might make sense since we're to finish with the current witness and then jump back to Mackey. And
I
then
would
finish with the
agree.
last one.
Yet we had talked with Ms. Kafer, and I don't know if Mr. Mackey's time is limited again this afternoon.
No, it was just that time this morning.
All right. Then let us move back to Mr. Gillum and finish there, please. And I apologize. I thought Mr. Mackey was under a time constraint this afternoon as well.
And Madam Chair, I believe we're at redirect for Mr. Gilliam, but I don't
We
know.
are at redirect, Mr. Bender. Yes, that is correct.
Thank you. Good afternoon, Mr. Gilliam. I want to try to clarify two things. The first was you had some questions from Commissioner Keene and some similar questions from Ms. Kafer. They both showed you a list of services from Pioneer One and from a RAP report, asking you whether those services were unique to DG customers. Do you remember that line of questions or two lines of questions?
Yes, I do.
And I wrote down here as part of your answer to both of those. I think you said that that those services were inherent in the service provided to non-DG customers. Can you explain what you meant by inherent?
Sure. And I'm sorry if I wasn't more clear. What I mean by inherent is those services are bundled together as part of the service provided by the utility. When we look at the, and I don't remember the exhibit number, but the RAP report that broke out the various sub-services, those are broken out because they are actually causing a cost to be incurred by the utility. And so the costs and the service are broken out separately. The utility has to plan for those specific services. For DG, however, it's very small. And as I think I mentioned before, the capacity of, at least the average capacity of most DG systems in Kansas is not unlike the load requirements of various appliances that may be in the home. And I think probably the best example is an electric vehicle, as I think I mentioned before. So when you talk about having to back up a solar system, if it stops generating for whatever reason, whether gradually or suddenly. The service that's provided by the utility to meet that customer's needs is no different than the service that's provided to a non-DG customer who plugs in their electric vehicle. Typical electric vehicle charging load is between 6 and 11 kW. Typical DG capacity in Kansas is between 6 and about 9 kW. So the service provided by the utility is the same. It's just all bundled together in one service.
Thank you. My other question was about the EV example you used, but I think you covered both of my questions with your answer. So I don't have any further redirect.
Thank you, Mr. Bender. I appreciate it. Going to Curb, Mr. Astrap for recross.
Curb has no recross.
Evergy, Ms. Dingus.
Nothing, thank you.
Pioneer, Southern Pioneer, Ms. Kafer.
Nothing, thank you.
Liberty Empire, Mr. Flaherty.
No questions, thank you.
KIC, recross, Mr. Vincent.
No questions, thank you.
KEC, KEPCO, Midwest Sunflower, Ms. Cunningham.
No questions, thank you.
And staff, Ms. Massentine.
No questions, thank you.
Commissioners, and I will start with Commissioner French.
One quick question, just based on the last line of questioning. If we're looking at that list of purported services that DG customers receive, I'm following your answer that all those are inherent in the services that every other customer receives. I follow it for whether I agree with it or not, I follow it for everything except for one of them. And one of those services was the export of energy. Would you agree that is a different service that DG customers receive that a standard residential customer does not receive?
Well, I'm glad you asked that for clarification. Export service is provided to the utility by the customer. It's the customer who's being paid for that export. So the person who's being paid is usually the one providing the service. But separately,
Isn't the customer being paid under net metering?
no. The customer is getting a credit for energy that it sent to its neighbor who paid full retail rate for it at whatever point in time that was exported, usually in the middle of the afternoon. And then when that customer, when the solar customer uses it again that evening, they get credit for that that provision of the energy essentially to the grid so that the neighboring customer could use it. So it's an accounting function, and the dollars are a wash.
Is it relevant? So I'm sorry. I guess, is it relevant whether it's a credit or whether it's a payment? I mean, the customer is being compensated for the export is I guess my point.
The customer is, well, there's two different levels. To the extent that the exports exceed the customer's usage during the month, in other words, that they net to zero, then those are all a wash because they're the utility receives retail value from the neighboring customer and provides that retail value to the DG customer. For exports that exceed that amount, the customer does receive a payment from the utility, at avoided cost rates, essentially for that excess. The important point, though, I want to be clear on is that exports, whichever way the service goes, I describe how I think it goes, is not part of the inflows that we're pricing out in this docket. or that we're discussing in this docket. And in fact, the grid access charge doesn't use any costs associated with exports in its calculation. So the costs we're talking about in terms of being discriminating are just the inflows to the customer and have nothing to do with exports.
I absolutely get that argument. In your opinion, would the grid access charge be lawful if it were calculated on the basis of incremental costs that were required to facilitate the export of energy from the customer onto the system?
To the extent that there are costs that the utility incurs as a result of exports, then I think it's completely legitimate for the customers to be responsible for those costs.
Okay, thank you. That's all I have.
So along that line, has the utility identified costs associated with the exports specifically?
No, the utility alluded to some cost categories in the testimony of Dr. Faruqi, but when we asked them to quantify those costs, they did not provide any support for that claim. And my experience in other states has been similar, that utilities will often claim that there are all sorts of costs for exports, but I have yet to see, other than maybe Hawaii, I've yet to see any proof of any actual costs incurred as a result.
So if I were to go out and get a distributed generation system tomorrow, would the utility have to come out and run a separate line or do something separate to receive those exports back into the system, back into the grid?
No, the interconnection process would require them to come out and verify that everything is connected properly, but you pay $100 for that service directly to the utility for that. But no, everything flows through your existing meter, existing service drop, and yeah.
Okay, thank you. Commissioner Keen, questions?
Yes, I do. As with Commissioner French, my question is a follow-on to the redirect by Mr. Bender. And this issue of inherent cost or inherent services. My question is this: in Kansas currently, however small the service demand by DG customers, whether that's taken individually or collectively, doesn't this demand come at a real fixed cost to the utility and its customers?
Just to clarify, when you say this demand, which demand are you referring to?
The demand by DG customers for their services, for their call on services from the utility.
It does have an impact on the utility if that demand occurs during the cost causation hours, which are the peak hours in the 4 summer months. Beyond that, the capacity is already there because it's built for those 4 hours. And if the peak load of the DG customer is at 10 o'clock at night or at 2 in the morning, whenever it is, then they are not causing any more cost to be incurred by the utility.
So you're saying that basically, going back to the planning process again, that the utility doesn't take into account the impact of that of the DG class in planning for its generation backup. Is that the contention?
You confused me with the last word there. They do take DG. I'm speaking generically here because I haven't been involved in any kind of resource planning process for Evergy, but they do take into account typically the capacity value of the solar collectively that's on their system, on retail customers, homes and businesses. And that is actually a benefit to the utility because it reduces the the load that's on the system, and as a result, they can build less generation, which is a benefit to everybody. Same applies to transmission. The load is less, so the transmission doesn't have to be as robust. So let me know if that answers your question. If not, let me try again.
I appreciate your answer. Let's pursue for a moment here this concept of inherent service. Are you saying by this that the fixed cost to the utility is going to be the same without regard to whether or not there is any DG demand?
Again, DG demand being the demand of the customer, the DG customer?
Demand on the utility's resources to provide service to the DG customers.
That's correct.
Okay. That's basically, regardless of whether they had the utility had any DG demand at all, they're going to build in the same cushion for peak and non-peak demand times, as I say, without regard to whether or not there's a DG demand at all.
Yes. Now, to be sure we're on the same page, I'm talking about solar resources. If a customer had a wind turbine or a few small wind turbines as their renewable resource, wind tends to be stronger at night. And so the pattern of generation would be different, and they may indeed be causing costs on the utility system because their load, the net load of the customer, could be occurring at the time of the system peaks in the summer.
I have no further questions. Thank you.
We keep going back to this. So I can remember years ago in visiting with the utility, they said the day after Thanksgiving, there is a significant spike in usage beginning about 5:30. And that is everybody turning on their Christmas lights all across the footprint of the utility. And they said, we have to plan for that. We know it's coming. Isn't the planning for the usage, I mean, utilities have to provide sufficient and efficient resources. So isn't the planning an ongoing process as it relates to the usage of the customers, whether it's they're buying more efficient air conditioning, whether EV vehicles are now going to be the thing in the future, that is part and parcel of the balancing act that they continually must, that's part and parcel of the work that they have to perform.
Yes, it is. And I think my point, and this is not a disagreement in any way, is that they are there, the utility is there to serve the needs of its customers. And speaking about the residential customers, there's DG and non-DG customers. The needs of those two groups of customers are not significantly different, as I showed in my testimony. So the difference is that the DG customers will reduce their consumption during parts of the day. Currently, at least in the test year in this case, the parts of the day that the load is reduced includes the hours of peak usage in the summer. So there's a reduction in load for the utility. And yes, at this point, I would guess they don't have to plan for it because it's so small. But when you get up to 5 or 10% penetration, probably they will be planning for it as a significant part or a minor part maybe of their resource mix.
Okay, thank you very much.
Chair Duffy, you're on mute.
I apologize. It is the bane of Zoom. I believe that completes our need for you as a witness today, Mr. Gilliam. So thank you.
Thank you very much.
And now we will go back to Mr. Mackey. And I do believe, Ms. Kafer, you are up first.
Yes, thank you.
And is Mr. Mackey, there he is, I see him. Thank you.
Mr. Mackey, you want to put your mic on? There you go. I believe, if I remember right now, that I won. The only questions I had for you concerned some questions the commissioners asked you on, and maybe Sierra Club also, on the list of the partial requirements, services, and what I'd like to ask you is a partial requirements customer, is that the same thing as identifying different services? Or is a partial requirements customer the same thing as different services when you're looking at those two things?
No, I don't think it is. I think the partial requirements customer is somewhat of a classification, right, of the type of customer. It's kind of a yes or no question. Is it or isn't it? The types of services is a different question. It's independent, I think, of how you answer the first question. So I would not view them as being the same.
The partial customers' usage patterns would not be the same thing as identifying different services.
Correct.
That's your answer. Okay.
Yes.
All right. That was all I had. Thank you.
Thank you, Ms. Kafer. And we are ready for Liberty Empire Recross.
No questions, thank you.
KIC Recross, Mr. Benson.
No questions, thank you.
KEC Kepco Midwest Sunflower Recross, Ms. Cunningham.
No, thank you.
And Curb Recross, Mr. Astrap.
Then from Curb.
Okay. CEP Sierra Club Vote Solar Recross, Mr. Bender.
No questions, thank you.
And staff, Ms. Messentine.
No questions, thank you.
Very good. And commissioners, starting with Commissioner Keen, do you have additional questions for the witness?
I do. Welcome back, Mr. Mackey.
Thank you.
Can you hear me?
I can, Commissioner Keen.
All right. Were you online during the colloquy the commission during its questioning had of Mr. Gilliam?
I was online for, I believe, most of it, but I know I wasn't online for all of it.
All right. I want to kind of call on your experience here for your take on Mr. Gilliam's concept of inherent services, because that is in stark contrast with the Pioneer Exhibit 1, page 3 presentation and some of the implications of that. So I would appreciate your take on this idea of inherent services, and I guess the concept that the fixed cost to the utility, I'm sorry for that, fixed costs to the utility are going to pretty much be the same, with or without regard to the demand the DG customers place on the utility.
Yeah, certainly appreciate the question. So first, my take on it is we definitely have a disagreement on the applicability of those services and what it means. I would agree that from a consumption side, all customers receive similar services, and the utility system needs to accommodate variation in load, and all customers, whether you're DG or non-DG, benefit from that. and the investments that have been made and the fixed costs that result. But what we're talking about here is additional services beyond that that are not related to variation in load, but are related to generation. And that's the distinguishing feature, is that the export service, these backup services, are related to a generation facility being on the customer site, and the value and the service that provides to the customer as well, right? The reliability. They could certainly choose to disconnect from the grid and rely only upon their generating facility. But the fact that they're interconnected with the grid indicates it's a different kind of service, right? Where they're able to use their generator and have the reliability that they desire. In terms of the fixed costs, I think that moves then into, well, how do you identify how much it should cost for this service? And I would agree. I think that's part of the point, is the fixed cost is the same. The problem is that the two-part rate doesn't treat it the same, right? The DG customer might pay zero in energy charges because it's able to export its extra power during some times of the month, import it back during other times, and it could have a net zero usage. And so the fixed cost being the same, they're certainly not being recovered the same.
Very good. I appreciate that. Follow-on question I would have is this. Notwithstanding the fact that utilities undoubtedly plan for fluctuations in demand for whatever cause, all of those kinds of planning decisions cut a cost, do they not? If they're anticipating certain demand during the cycles of the day or seasons of the year or whatever it might be, all of those planning decisions, whether it be with respect to generation or other attributes of the utility services, come at a cost to the utilities and their customers, do they not?
There is certainly a cost to plan for the facilities, and I think it's important to distinguish between the different types of planning. And a lot of the conversation that I heard revolved around the system peak, and that's certainly a relevant peak that's used for planning generation resources. There's different peaks that are used in where the transmission system is designed around a different type of peak, more of a regional peak, for example. And as you move from generation to transmission to distribution to the ultimate customer, there's a loss of what you might call diversity, where when you finally get to the customer, it really doesn't matter what the system is doing. It matters what that customer is doing, right? And so when I talk to, at PSE, I believe we have some of the best distribution system planning and design engineers in the country. And when I talk to them, when it gets to the level of the distribution system, they do not plan on intermittent, non-dispatchable solar resources as being able to relieve any capacity constraints on the distribution system. You just can't count on that if you want a reliable distribution grid. Now, do they, in aggregate, tend to operate on average during system peaks, which drive generation resources and dispatch and costs as well? Yeah, they do. And that will depend, I guess, on the utility and the geography as well, as to what extent they contribute to those peaks. But yeah, the fixed costs at the distribution level are the same. There's not, at least I haven't talked to an engineer that says, oh yeah, we were able to reduce the size of a customer's transformer because they put in solar DG. Those costs remain the same. And there is a cost in all kinds of planning related to maintaining a reliable grid.
Once again, Mr. Mackey, thank you very much for your most articulate and nuanced answer. I appreciate it very much. I have no further questions.
Thank you, Commissioner King. Commissioner French.
No questions, thank you.
Okay, so just real quick, Mr. Mackey, so you're saying they do not count on the solar, for example, the solar input back out onto the grid to offset any of the other needs, to offset the needs of the rest of the grid, or yes? The
Yes, I
demand
would.
placed on the grid, is that correct?
Yeah, Madam Chair, that what I was saying is that they don't give credit, if you will, for that generation as relieving, load requirements of the grid. Because it's not predictably going to be there at a certain level. It's not something the utility has control over. Customer doesn't really have control over it. It's dependent upon the sunshine and whether cloud cover comes. So my point is the utilities do not plan on having the full availability of a solar resource to serve its capacity needs on the distribution system. Does that?
So it's more related to the predictability of the solar and not necessarily the size or the amount of generation that was put back on by the solar. It's more the unpredictability is why they don't plan for it.
That's a good question. I think there is still some impact of size of resource, right? Because, yeah, I mean, that probably matters too, but it is more the unpredictability. If you know that if there's a large generator out there that you have more certainty around when it's going to run, you can plan for that. But if you have a resource that is intermittent and not dispatchable, it's difficult to plan for that. So the system engineers I talk to say they don't plan. They don't plan on those resources being available because you can't count on it.
Okay, so I can get that here, but what about in Hawaii where Mr. Gilliam was saying it was like 34% of their generation. So is it because it's sunshine and fun all the time, or how do they deal with that?
Yeah, no, that's a good question. That's probably a completely different situation, right? Where there are issues of having so much generation on the distribution feeder that it can actually exceed the load on that feeder and then backfeed into substations and even onto the transmission system. So that probably is at a point at which it's definitely being considered by utilities that find themselves in that situation.
Okay, all right. Thank you very much, Mr. Mackey. And I believe that does complete our questioning of you. Somebody has left on their mic. If you could turn that off, it would be helpful. All right. Thank you, Mr. Mackey.
My pleasure.
You are dismissed. Well, folks, we're coming to the end of the line. And it appears that Dr. Robert Glass is our next witness. And with that, I'm not seeing there he is. Hello, Mr. Dr. Glass. And if he could be sworn in, please, Ms. Smith.
You could raise your right hand. Do you solemnly swear that the testimony you're about to give and the cause now pending will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you. And Ms. Massentine, are you going to tender the witness? Or
Yes.
Mr. Bailey?
I will be.
Okay, thank you.
Good morning, Dr. Glass.
Morning.
Would you?
Afternoon.
Oh, excuse me. You're right. Afternoon. Would you please state your full name and business address for the record?
Robert H. Glass, 1500 Southwest Arrowhead Road, Topeka, Kansas. Zip code is 6604.
Thank you. Please state your title and your role at the commission.
I'm Chief of Economics and Rates section within the Utilities Division, and I think the title kind of describes what I do. I do economics and I do rate design.
Did you cause to be filed in the docket staff's initial verified comments on rate design on August 14th, 2020?
Yes,
Did you cause to be filed in this docket staff's verified reply comments on rate design filed September 10th, 2020?
yes,
And did you cause to be filed in this docket staff's or your direct testimony filed November 13th, 2020?
yes.
Do you have any corrections to make to any of those documents at this time?
None that I'm aware of.
And if I were to ask you the same questions today, would your answers be the same?
Yes.
Thank you. I'll tender the witness for cross-examination. Oh, excuse me. I'm sorry. Backing up a little, commissioners, staff moves that its initial verified comments on rate design, its verified reply comments on rate design, and Dr. Glass's direct testimony be incorporated into the evidentiary record in this docket.
Thank you. Is there any objection? Seeing none, it is so ordered. Very good.
I now tender the witness for cross-examination.
Great. Thank you, Ms. Massentine. We will begin with commissioners. And Commissioner French, do you have questions for this witness?
I have some great questions for Dr. Glass, but I am going to reserve them until after the parties examine.
Very good. Thank you. And Commissioner Keen, do you have questions for the witness?
Just a couple to start off with. Good afternoon, Dr. Glass.
Good afternoon, Commissioner.
Been a while. Good to see you again. Where have we been? Hiding out, I guess, huh?
Yes.
Do you have available to you Pioneer's reply comments?
The reply comments?
Yes.
Second here. Okay, I've got their reply comments.
Yes, Bob, if you could turn to page 5, please. Paragraph 12.
Okay. Okay, I'm there.
If you would, please, just take a moment to review that.
Okay.
Dr. Glass, I would appreciate your response to their comments.
Well, what we meant by rates were, for example, if the 3-part rate had been applied to both DG and non-DG customers, our interpretation, and this is a rate design interpretation, not a lawyer, don't pretend to be a lawyer. Our interpretation of most of what the Supreme Court said was that if the DG customers and the non-DG customers had the same charge, same rate for customer, demand, and energy, then that would pass the Supreme Court decision. So in a sense, maybe we weren't specific enough, but that's what we meant, which is pretty close to what they said, except they emphasized energy. We meant that if all 3 charges are the same for both DG and residential charger and non-DG, then that would be okay. We think that would be okay. We're not certain when it comes to interpreting what the Supreme Court meant.
All right. With regard Did I interrupt you?
No.
Okay. With regard to your suggestions have to do with utilization of a minimum bill approach.
How do you want, what are you looking for?
I haven't finished the question quite.
Oh,
I was
okay.
contemplating it. Sorry.
I'm sorry.
There's an inherent lag in this system, and I added to it. Yeah, with regard to the minimum bill suggestions that you're making, why is it you believe that approach is preferable to the other Evergy option, which was the grid access charge? In a nutshell, why do you believe that would be a preferable approach?
Because we don't think that the grid access charge would pass whatever test is set up by the Supreme Court in their decision.
Okay. And you're concerned, if I don't mean to put words in your mouth, but I'm taking from what you're saying here is that you believe that the distinctions that have been advanced so far to try to distinguish the grid access charge from the demand charge haven't persuaded you.
Well, we're sympathetic to the grid access charge, but the grid access charge is justified in terms of a particular set of costs, the costs of exporting. And that is truly a different service. And so if the grid access charge were based upon that cost, then I think that would pass the Supreme Court test. However, it's not based upon that cost. When they actually calculated the grid access charge, they used an estimate of the subsidy, and they basically used about half the subsidy to calculate it. Well, that seems to fall right back into what the Supreme Court did not want, which was that makes it almost a demand charge, and that makes it a unique charge to distributed generation customers. And we think, I'm not certain here, but we think the Supreme Court would say no to it. We think. I'm not guaranteeing anything here.
I'm stunned by that. A very nuanced answer, and I appreciate it very much. There's some hues of gray in there that are of consequence. I appreciate that. With regard to let's say hypothetically, the commission did adopt a form of a minimum bill. As postulated, and with all the conditions that surround it as of right now, as I understand it, from the presentation Evergy gave, it would have a relatively de minimis effect on the non-DG customer. Is that your take?
Well, there would be a minimum number of bills that were affected. And yes, I think that it would be, for the most part, de minimis. And they have made provisions for low income. And although it's kind of been asserted that Evergy doesn't have a low income program, I can personally testify. My wife has grandchildren who are college age and have roommates who supposed to pay a bill, don't pay a bill, and disappear, and are then stuck with an electric bill. And we called Evergy, and Evergy had a series of people you can call and deal with. So the people that you talk to at Evergy, the customer representatives, actually do have seem to have at least a list if you have a low income problem or something like that you can go to. So I do think that Evergy is not completely in the dark about this. I would argue that they're actually proactive.
All right. Let me ask you a really tough question. Given the disparity, again, with respect to the minimum bill, between the initial $35 being proposed by Evergy and their acknowledgement that to cover the fixed cost, it really would require $77, and that perhaps this is but a first step on a longer journey. And of course, I suspect that longer journey is going to take place through a succession of prospective rate proceedings. My question is, are we sure this isn't, it's a loaded question, Bob. This isn't a springboard to a general increase in rates?
Well, first, I'm not going to be here forever, but I doubt staff is going to be thrilled about supporting a minimum bill that exceeds $35 to $40, something like that. I mean, the minimum bill is a stopgap, intermediate measure. It doesn't fit with our philosophy of what we like to do with rate design. It's an end use way of designing rates, and we don't like end use. We prefer behavioral. That's the reason we don't like the heating discounts. We prefer a behavioral approach to designing rates. And so we don't see the minimum bill as a permanent solution. We see that as a temporary solution, and we hope that, and we would encourage Evergy to come up with something better in the rate case.
Okay. We had public hearings a month or so ago in advance of this evidentiary hearing. There were a lot of DG customers who testified at that time. My take on that is that I think generally they didn't feel that the phrase minimum belonged with the phrase minimum bill and $35. I think they were concerned about that. And so on that, I think my most profound concern has to do again with those least able to pay, those on the bottom of the economic ladder who would be least able to pay on that minimum bill. We have certainly representations from the company, I take it at face value, that they would take certain steps to mitigate that. In the event we chose that route, wouldn't it be advisable to, well, there's just so many different gradations of choice there that we're confronted with there. Does any of this give you pause for concern?
Well, low income certainly does, but my experience with low income is very similar to Chair Duffy's experience with low income in Topeka. I got sent to a committee meeting of low income advocates, and this was in 2009, 2010, and they all pointed out exactly what Chair Duffy said, that the low income customers that they knew were not low use, they were high use, and they lived in old homes in Topeka. And the second thing, my second example of this is when Jeff Martin was in charge of regulatory. Both he and one of the commissioners were very concerned about low income, especially in Topeka and Wichita. And they did quite a bit of work trying to identify areas. And it turns out the areas of high use but low income customers were apartment complexes. And we tried to work out a program, and it's just difficult when you start getting to renters. It's very difficult For example, improve the premise, make the premise more energy efficient, and then keep the rate the same, because these are low-income customers. You make the building better, then you're going to raise the rent. There's always that possibility. We had a very hard time trying to set something up, and eventually that ended up just kind of fading away as that commissioner left. So yes, I'm concerned. I'm concerned about low income. I'm concerned about low use, low income. I'm also concerned about high use, low income. But it's a hard problem to deal with. And I would suggest that probably the best way to deal with low income is income assistance rather than, mitigating bills or something like that. But I'm not an expert on that, and that's an opinion that you could certainly ignore and probably not lose any information.
Well, I appreciate your answer. My last question for you, Dr. Glass. The Supreme Court, in its opinion, advanced several options. We've discussed the pros and cons of several of those options during the course of the last 2 days. Our most recent testimony, which was from Mr. Gilliam on behalf of the CEP group, I think he put some stock in time of use. Would you give us the benefit of your take on time of use as an option?
Time of use, staff has always advocated the approval of time of use pilots, time of use programs. We think they're a great idea. Here's the problem. I believe Evergy, Kansas Metro, or Metro Kansas, whatever their name is, they have a time of use rate, and they have advertised, and I know that their advertising budget was over $1 million because it was in the 480 rate case. And they really went out and tried to get as many customers as they could. They got 977, the last report I saw. And I'm not sure they all lasted through the summer, but they have come in, and there was a cap of 1,000. They're asking to raise the cap. I'm sure that we will approve that. At least I advocated raising the cap. So maybe you get over 1,000. There are over 40,000 customers in Evergy, Kansas Metro. That might include Missouri, but I think it's just Kansas Metro. Kansas Metro, that are on the average pay bill. In other words, they pay the same amount every month, and then that's readjusted every year. At least that's the way it was a couple of years ago. That is exactly the opposite of time of use. That is exactly the opposite of any rate design that provides a price signal to customers. And that's what customers prefer. Customers don't want a price signal. Customers don't like time of use in general. A few customers do, the ones that can benefit probably. But you don't see 40,000 people signing up for time of use, even with significant advertising. Basically, my experience, dealing with rate design has been pretty simple. Most people never want rates to increase. And even when you decrease rates, they'll tell you that, no, they actually raised the rates on me. Evergy Central lowered rates $50 million. And I don't know how many people have told me, no, you're lying. They raised the rate on me. Customers think that the rates are always going up. They don't want to think about them. They want an average bill. So you're not going to make customers happy with any rate design is basically my conclusion at this point. The best you can hope for is you can keep them at bay and they don't show up at your door with pitchforks and torches.
I do have one more question. You don't need to call it up, but my reference point here is the KEC group reply comments. One of the observations, I think, if I can hopefully fairly portray Mr. Shepherd was that one concern with the time of use rate design was that it didn't address the circumstances where we have DG customers with net zero use.
That's true. It doesn't. It doesn't.
I'm going to ask you, could you elaborate on that just a bit?
Well, if they have net zero use and most of their use their use, let's say, is at night, which would seem natural, then they're going to be paying a very low charge. The few times during the day when the cloud goes over or something like that, and all of a sudden they need energy from the company, then they're only going to pay for those little spurts of energy unless their system goes down for, several days or something like that. So they're not really going to get to the fixed costs because the rate that's usually set for night is fairly close to the marginal cost. And so there's just not going to be the collection of any kind of fixed cost there.
Dr. Glass, thank you very much for your very responsive and nuanced comments. I have no further questions at this time.
Thank you, Commissioner King. Good afternoon, Dr. Glass.
Good afternoon.
I have a couple of questions right now. So as we discuss, or as it has been discussed about in staff's comments, that the utility could start some programs. So if you're low income, you could come in or use LIHEAP. Are we not starting down a slippery slope that we ask the company to, the example you gave with your grandchildren. So the person sitting behind that phone makes a determination as to whether I can help you or go fish.
That was my understanding.
So, and you state that the company has not had a low income program. Is that correct?
Well, okay, Evergy Central, no, as far as I can remember. They haven't had a low income program, but they use different agencies in the state, and they are pretty good. I mean, they really try to guide people to where they can get support. I mean, and they seem to me to go outside of the of just what's on a list. I mean, they really do seem to make an effort. I think they err on the side of too much information rather than too little information.
So let me ask about LIHEAP. Are you aware if that program prior to COVID was that program well used in the state of Kansas?
I really don't know anything about that program. I'm sorry.
If I remember correctly, I did call the director of LIHEAP, and he said it was not unusual to turn back dollars. It's hard, as you have stated, to get people to funnel them into programs sometimes. I imagine, as I've talked to bus riders, they're like, Miss Duffy, you don't understand. I work 3 jobs. When am I supposed to pick up the phone? I can't have a phone out and make phone calls. I don't have time. I'm just trying to get to my jobs. And that's about all I can do each day. They are faced with the issues on a daily basis of just staying ahead of the curve. And I state that I think as a reality for a lot of folks who are working multiple jobs, multiple low paying jobs to keep their family fed and to keep a roof over their home. Plus, I believe there are a lot of people who will not take advantage of government programs for a variety of reasons. Why? It's better used by somebody else, or they don't have the time, or they don't have the inclination. So as you talked about Evergy's experiment, where their program with time of use, and you believe that people just didn't take advantage. Was that the fault of the company and the way that they approached people? Or do you, is it your opinion that it's just folks don't do it?
Well, they spent over $1 million. I don't know how much they spent. I think their total budget, I think we tried to stop it at right around 2 million. And I don't, the last thing that I saw, they clearly hadn't capped out. But they spent a lot of money, and they did a lot of advertising. I mean, they came into us with the different advertising approaches, the different marketing approaches. They really seemed very serious about it. And as I said, they did get the last report said 977, and they want the cap of 1,000 raised. But the summer peak price is a little over 25 cents a kWh. That would cause most people to think twice about it, because something happens, and well, let's just assume you've got teenagers and they're working night jobs and they're home during the day. You know, 25 cents a kWh, and you're running air conditioning at 68 degrees in the summer.
Been there, done that with teenagers. So I do have a question. When was the last time that the company asked for an increase in their basic service charge?
Oh, the customer fee, the service charge? Yes.
Yes.
I can't think of a time that a company hasn't come in and asked for it.
And typically, what was the response of the commission last time they asked?
Well, even in this docket, where there was a $50 million reduction, the customer charge, I believe, either stayed the same or went up 25%. I do not remember which. So they did not reduce the customer charge. The customer charge, the service charge, is something that ever since growth stopped in Kansas and per capita usage stopped growing and started declining, electric companies have become like natural gas companies and wanted increases in the customer charge just for revenue protection. I mean, it makes sense in profit maximizing terms. It's an insurance policy. And, you know, they'll ask for $22 and, you know, they'll get a $1 increase or something like that, or maybe no increase.
Okay. But it's,
I'm sorry.
No, go ahead.
I was just going to say, I have yet to meet a commissioner that liked the customer charge.
That's probably true. Okay, thank you. And at this time, we will move on to Evergy for questions.
Thank you. Good afternoon, Dr. Glass. Good to see you.
Good afternoon.
You discussed time of use rates a little bit with Commissioner Keene and Chair Duffy. And I believe you said to Commissioner Keene that the time of use rate would not increase a utility's fixed cost recovery. Am I remembering that correctly?
For a distributed generation customer that is using their solar during the peak period, yes.
And so would you agree then that a time of use rate really wouldn't address the subsidy issue that you've discussed in your testimony?
that type of time of use, yes. But one of the things that, I mean, I'm sure you're aware of this, Evergy has the electrification program, and they want to attract more space heating customers and EV customers. But the space heating ones are the ones that really make a difference. We already have one IOU in this state that has a winter peak. And winter peaks are not middle of the day. Winter peaks tend to be in the morning. And I went back and looked at Evergy and their 12 CP in this rate case. And the peaks were, the winter peaks were at, 8 o'clock and 9 o'clock in the morning. And there was one at 8 o'clock in the afternoon or in the evening. All times, I mean, this is December, January, February, all times when the sun isn't shining. So if you designed a time of use, it seems to me you have to have a pretty sophisticated time of use, not just a time of use for the summer. You need to have a time of use for the winter, especially if you get more and more space heating customers and move towards something like a winter peaking utility, then you have to, it has to be sophisticated. I'm sorry, I mean, the problem with this docket is there are never any simple solutions, and all simple solutions seem to have unexpected consequences. I'm sorry.
Thank you. Have you been listening to the hearing throughout today?
I made a couple of bathroom breaks, but most of it, yes.
Some of Mr. Gilliam's testimony, and I'll see if you remember this or not, but he was talking with the commissioners, and he seemed to suggest that the utility incurs basically no cost to serve DG customers if they're using power during off-peak hours. Did you hear the discussion around that?
Yes, I heard him say that, yes.
And what's your reaction to that? Is that true?
I don't believe it is, because,
Why is that?
well, for one thing, he's saying just the energy charge, you know, that energy should cover it. There are other costs. Plus, you have to, the distribution system is different than the whole system. That's the reason with the distribution system, we use non-coincidental peak. And if that's in the winter, I mean, or I'm sorry, when it's dark, if that's when they're using the system, and that turns out to be the system peak for that part of the distribution system, then they are in fact using the capacity. And so they should be paying for part of that capacity. As I said, the distribution system is different than the generation system or the transmission system, but that's the reason we use non-coincidental peak to allocate, at least staff does, to allocate distribution costs. And so if that's what they're doing, and if they are, you know, a significant portion and they're creating capacity costs at that time, then yes, they are creating a cost. Well, almost everybody creates a cost when they use electricity. I mean, an individual person, no, but a group, yes. You know, incremental costs are really hard to find, really hard to measure, but group costs, yeah. Am I not hearing something?
No. Ms. Dingus, do you have other questions?
I think we maybe lost Ms. Dingus.
Okay, why don't we wait for a second, see if she comes back on?
Madam Commissioner, while we wait here, I had a question. Are we supposed to have moved for the admission into the record of all of our initial and reply comments, or are those considered part of the record already?
I would believe they are considered part of the record. Mr. Fedotin?
Yeah, they should be part of the record.
Okay, thank you.
But if the parties are at all concerned and want to enter them, they can, but I certainly don't think it's necessary.
is Michelle on? Michelle, do you have somebody in the waiting room? Do you have?
She just now popped up in the waiting room again, so I was watching for her. She should
Very
be
good.
coming back in now.
Thank you. We'll just wait for her to come on. Distinguished, are you with us?
Chair, this is Brad Lutz with Evergy. I've been texting Kathy. She is attempting to reconnect right now.
Okay.
For the brief moment she had joined again, she didn't have any video or sound capability, so I'm not sure what's going on her end.
Okay, how about this? Why don't we take a 5-minute break? Allow her time to get back on. This will be the last break. The time is 2:30. We will
On our end, it's somebody else trying to
we will
connect.
reconvene at 2:35 and hopefully
They
by
lost
then.
connection, and then when they tried to go connect again, they didn't have any
Michelle,
sound or video.
Michelle, we are picking up your audio. So we will reconvene here at 2:35. We're going to take a 5-minute break, Michelle.
Thank you.
All right, thank you. Michelle? It's Susan. Were we able to get Ms. Dingus back on?
It looks like she has reconnected and hopefully she'll be able to hear us and can speak again.
Very good. It is 2:35. We are back on the record. And Ms. Dingus is with us. There you are. All right, very
Here.
Very
I apologize. I got an email from the company saying our system was having trouble and I got kicked off about a minute after that. So I will try this from my home, my personal iPad, and see if I can make it work.
Very good.
Dr. Glass, I didn't hear your entire answer, but I'm sure it was wonderful. So I will just move on to my next question. I apologize for that. Your discussion, Dr. Glass, of the subsidy that exists in favor of DG customers, that is not related to the question of whether there are additional or incremental costs caused by DG exports, but it's instead related to the fact that DG customers are not paying their share of embedded costs because of the change in usage that occurs. Is that correct?
That's correct.
And do you agree that it's the fact that DG customers are generating their own power and exporting at times, that fact is what creates this cost shift or subsidy, as it's been referred to, that we're trying to address with the rate design in this proceeding?
Yes, that's the fallacy. They reduce their energy usage, but they really don't reduce their capacity requirements very much, certainly not in proportion. So there's the subsidy.
And the grid access charge, you were talking earlier about how that was calculated, but you agree that your understanding is it's calculated by looking at the amount of that cost shift or the amount of that subsidy that's caused by these customers generating their own power. Is that right?
Yes.
Thank you. That's all I have.
Thank you, Ms. Dingus. Okay, Ms. Kafer.
No questions.
Very good. Mr. Flaherty.
Yes, thank you, Your Honor. Good afternoon, Dr. Glass.
Good afternoon.
Could I have you turn to page 5 of your responsive testimony?
Okay.
I want to ask you some questions relating to your testimony that appears on lines 3 through 7. Do you have that?
Yes.
So in the first sentence, if I understand that correctly, you state that the two-part rate design used by the commission gives a subsidy to DG customers. And then the second part of that, or in the second sentence, you explain why the use of the two-part rate design creates the subsidy, correct?
Correct.
And you indicate that the two-part rate creates a subsidy because it collects substantial capacity cost in the energy charge, and that DG customers avoid paying their share of those capacity costs by reducing their energy usage, correct?
Correct.
And just so the record's clear, it's not the fact that the rate design is using a two-part rate with a fixed charge and a volumetric charge that causes the issue. It's the fact that a lot of the fixed costs are charged through the volumetric rate, correct?
Correct.
And as a general premise, is there some logic when designing rates to collect fixed cost through a fixed rate and collect variable cost through a volumetric rate?
I've heard that for 10, 12 years. That's not the way an economist would think of it. That's the way a rate design person who came out of engineering would think about it. The way an economist would think about it, this is the way Seb Bornstein explained it, but this is also basically what the Coast two-part rate design that he advocated back in the 40s, and he said had been around, for 30 years. What you do is you set the energy charge at the marginal cost or the incremental cost. Then you collect everything else you need from the fixed costs. That's a backwards way of getting at what you just said. But it has, I would say, basically the same result. You collect the fixed cost with the fixed charge, and you're collecting the variable cost with the variable charge.
So if we were going to design rates, and let's say the utility collected its fixed cost through its fixed rate and collected its variable cost through a volumetric rate, that would avoid undue discrimination or subsidies from occurring among residential customers within the residential class, correct?
Yes, I think so, but you have the problem of if everybody's paying the same fixed cost, there is variable use and demand, variable use of capacity. So, but there are always subsidies intraclass. There are always subsidies. So I guess I would agree with you, yes.
Okay, and that type of rate design would also comply with for more or less the cost causer principle that was discussed in the Kansas Supreme Court decision, correct?
Correct.
And as long as the rate design collects a lot of the fixed cost in the volumetric rate, there's going to be the situation where the residential customers who use a low amount of energy are being subsidized by those residential customers who use a large amount of energy, correct?
That's correct.
And the minimum bill option that staff is recommending in this case partially reduces the subsidy that residential customers who use a low amount of energy are now receiving under the current rate design, correct?
Correct.
So Commissioner Duffy, I can get witnesses to answer yes or no. I want to put that on the record. So the customer having to pay that minimum bill is not being treated unfairly under the cost causer principle if that customer is paying for the cost incurred by the utility to serve that customer, correct?
That's correct.
And that customer is not being unduly discriminated against or as compared to other residential customers, correct?
That's correct.
So it would meet the standard, I guess, that is in the Kansas Supreme Court decision, in your opinion.
Yes.
In fact, in this particular case, if the commission decided to use the $35 minimum bill that's recommended by Evergy, the residential customer having to pay that $35 minimum bill is still likely being subsidized by the other residential customers who use a large amount of energy, correct?
Oh, that's a harder one because in Evergy Central's a residential class, you have big houses, medium-sized houses, apartments. And when you get to apartments, I'm not really sure how much energy apartments use. And I can tell you that a member of staff, Dr. Ellis, in November, her bill was $34.13. So the minimum bill would have nailed her for another 87 cents. That's a harder one that is exactly the reason that staff initially suggested, although data is not available, but we suggested that you have a tiered minimum bill. And so for apartments and trailer courts, maybe you have a lower bill. That was the reason, that problem right there.
So you could actually have a tier bill or different bills for different types of residential customers.
Yes.
Okay. And there was some discussion yesterday about how the current basic service charge that Evergy has and what other utilities, I think, call a monthly customer charge or facility charge, that is currently like a minimum bill. Would you agree with that?
Yes.
And finally, There's been some concerns raised about the low-income customers during this hearing, and wanted to ask you a few questions regarding that concern. And I think you mentioned in response to one of Commissioner Keene's questions that, and I think you referred to Chair Duffy's example about low-income persons who live in Topeka that are renting old houses that have poor insulation, older windows, less efficient air conditioning units and appliances that might result in them being a high user of energy, or customer that uses more than the average. Do you agree that there will be some, I think you already agreed, but just to confirm it, that there will be some low-income customers who might use more than the average residential customer?
Yes.
And for that type of low-income customer, adopting a rate design that collects fixed costs through the fixed charge and the variable costs through the volumetric charge, that could actually result in an overall lower bill to that low-income customer compared to what their bill is currently under the two-part rate design, correct?
Okay, yes, but it would be minimal. But yes, there would be, if they're above average usage, then yes, they would probably save money.
Okay, thank you. That's all I have. Thank you. Thank you, Doctor.
Thank you.
Thank you, Mr. Flaherty. KIC, Mr. Vincent.
KIC has no questions. Thank you.
Very good. Ms. Cunningham,
No questions. Thank you.
Curb, Mr. Astrab, do you have questions?
I do. Thank you, Commissioner. Good afternoon, Dr. Glass.
Good afternoon.
I want to talk to you about your review of the minimum bill proposal, okay?
Okay.
In your direct testimony, you note that the minimum bill would be applied to all residential customers regardless of their DG status, correct?
Correct.
And I believe it was yesterday, Commissioner French referred to the minimum bill as, quote, like the bill you cannot escape. You kind of agree with that sentiment? Well, short of like disconnecting from the grid or paying more than the minimum bill.
Well, you can't escape the customer charge either.
Sure. Right. And in response to some questions from Mr. Flaherty, you indicated that a minimum bill and a customer charge are fairly similar in appearance, right?
They're similar to appearance if you, in this particular case, if it's $35 and you usually less than 78 kWh a month. If you use more than that, the minimum bill has no effect on you.
Sure. And so in the situations where a person is impacted by the minimum bill, that person might perceive that as being a type of customer charge, correct?
I hate to guess at how customers are going to perceive charges. I'm sorry.
Sure. Well,
Maybe
I know, but
I don't know.
Understandable. I know earlier when you were having an exchange with Commissioner Keene, you mentioned people running with pitchforks and torches regarding minimum bill issues. So at some degree, I think based on your experience, you probably have a good insight of what customers might react to on certain things, wouldn't you?
I know what extreme I deal with the customers that are irate.
Sure.
When public affairs doesn't want to deal with them anymore, they send them to me.
I can see why.
Well, I mean, I'm old and people have called me a lot of names for a long time. So I'm fairly thick-skinned and hard to insult.
Understandable. I want to talk now about DG customers on Evergy systems. We've been talking a lot about DG customers, but to you, what makes a residential customer cross that threshold to becoming a DG customer and then being subject, in the past at least, to the RSDG rates?
Why do they put the solar panels on?
Is that what it is? Do solar panels make a residential customer become a DG customer?
Yes.
Okay. So even a single panel would make that distinction as well then?
Yes.
Okay.
I think. If you hook the thing up and you're generating electricity and you have to file a net metering, you have to sign a net metering contract. I mean, I don't know all of the stuff that's involved.
Mm-hmm. Fair enough. But the general characteristic is they have at least some degree of panels installed and capacity connected to the grid, correct?
Correct.
And you'd agree with me that among the DG population, not all DG customers have the same capacity of DG installed, correct?
I think that they come in increments, but yes, I mean, I've seen, well, you can go up to 15 kW.
Sure.
And
But not everybody has 15 kW installed.
right. And by the same token, I believe Mr. Lutz yesterday mentioned people who had less than 1 kW. So yes.
Okay. So there's a wide degree of kW or DG usage within Evergy's grid. And so to that extent, would you agree that DG customers don't necessarily have the same, I guess, standby reliance on Evergy among each other, right?
Well, there's a lot of heterogeneity, but there's a lot of heterogeneity everywhere. That's why you use averages.
Sure. But in a situation where somebody has less than maybe 1 kW of DG installed versus somebody has 15, their use of the grid might differ, right?
Certainly.
Certainly the one using less than 1 kW of solar electricity would probably be using more electricity from Evergy, right?
Okay, I don't know if you've looked at Evergy's report on the RSDG class. There are some strange customers in there.
Okay.
There are some customers that they're generating over 1,000 kWh a month, and they're using 7,000.
Oh.
I mean, I think there was one customer who's using 10,000. I don't know if they have a second building or they have grow lights. I'm not sure. I don't know what's going on. But you cannot, as far as I can tell, there's so much heterogeneity that it's next to, I don't know what a typical DG customer is.
Fair enough. But you'd agree with me that because of this, I guess, wide variance of usage and installed capacity, that taking a minimum bill rate design may not necessarily capture each and every single DG customer, correct? Some would be effective at it, some might not be.
Yes, I mean, it's a stopgap measure. I think I made that point.
Yeah. And let's talk about that stopgap measure. So it's staff's position that the minimum bill should only be used as a short-term solution?
We would hope that something better would come along, yes.
Fair enough, okay. And so initially in your direct testimony, in your review of the minimum bill, staff made a recommendation to modify Evergy's proposal to include a tiered system among the residential customers. Is that right?
That's correct.
And that's based off of different types of residential dwelling situations?
Right. We suggested at a minimum 3, if you had the data, you could make it more granular. They don't have the data. You can't even do those 3.
Right.
And by the way, I don't blame Evergy for not having the data.
Sure. But in any event, they're unable to make that modification that you guys requested, correct?
That's correct.
Okay. And then earlier in your exchange with Commissioner Keene, you mentioned staff may have a hard time following through with a minimum bill that goes beyond $45. I believe I heard that.
I thought I said 40, but
it might
we
have been 40.
would like to see it go. We would need a lot of persuasion to get it above 35.
Okay, thank you for that. And then earlier yesterday, were you around when Mr. Lutz testified that Evergy was not willing to put a hard cap or limit on how high their minimum bill might go in the future?
Sure, yes.
Okay. So with both that last statement from Mr. Lutz and also Evergy's, I guess, inability to be able to break down the information, does that give you or staff some concern regarding the minimum bill proposal?
Well, the fact that you can't have the 3 tiers makes it a less favorable proposal. The fact that they discussed mitigation remedies for low income alleviates some of that. My personal experience as a student living in a student slum with, if I was lucky, I had 450 square feet of living space, where I'm sleeping, eating, and almost taking a shower in the same room. I would really like a lower minimum bill for apartments. But that's just from my personal experience, and that's probably a very biased outlook on my part and should be ignored.
Understandable. In regards to this tiered system, would that in any way create a like a mini subsidy among those tiered classes at all, or no?
I don't know how it would.
Okay, fair enough.
Can you explain it to me?
No, I'm just asking generally as a question if it would or not. Thank you. And continuing on about the minimum bill being this interim solution, why does staff at this time see the need to choose what is essentially this brand new rate design structure for Evergy?
Well, one, it's a minimal change. I mean, it's even more minimal than the grid access charge. So it's not like a huge change. It's a very small change in their rate structure. And I really feel like after all this time, we need to be going forward, not returning back. The two-part rate for years was adequate when you had, customers basically behaving as customers without their producing their own energy. There were studies done, there's statistical studies, and demand and energy use were correlated at about the 82% rate. That's a very high correlation. And that was a pretty good suggestion that the two-part rate did a good job of capturing fixed costs, even though they were capturing them in the energy charge. As soon as you start, altering that correlation, that's what DG customers have done, then the rate design fails. And I think that there are more reasons for that rate design to fail in the future, because there are going to be more and more opportunities for other things. For example, it really doesn't make a lot of sense if someone's going to charge a vehicle at night, it makes sense to have a different rate for that. So I think that there are a lot of reasons to move away from the two-part rate going forward, not just because of the DG customers. The DG customers are what brought it up here. I think this is the opportunity to start moving away from it. I think that if Evergy wanted to go to some sort of mandatory time of use, they would have to do an enormous amount of education to convince people that they're not going to get, the short end of the stick. I really don't know how you deal with this going forward, but the two-part rate seems to be, it seems to be increasing in its dysfunction going forward.
Okay. Thank you, Dr. Ross. I appreciate that. Now, I want to talk to you about staff's hesitation to see the minimum bill go above $40. You've read through Mr. Kalsick's direct and cross-answer testimony, correct?
Correct.
So you're familiar with his analysis of the break-even level as the minimum bill goes up?
Right.
And generally speaking, do you agree with Mr. Kalsick's analysis there?
Well, yeah, I mean, it's based upon Dr. Faruqi's analysis, which is based upon, earlier in this docket, the estimation of demand. So yes, the 77 seems like the reasonable number. Yes.
Okay. And so you agree with Mr. Kalsick's conclusion that if it were to reach that $77, customers who are using approximately 870 kilowatts hours a month or below would see an increase in their bills?
Didn't he say 850?
Yeah, I apologize. 850. My apologies.
Yes.
And the number of bills that would be impacted under a $77 regime is, of course, going to be more than what it would be at the $35, right?
Yeah, well, it'd be half, right?
Right, exactly, yeah. And so staff's concern revolves around the potential for the minimum bill to increase, thereby capturing more customer bills, both DG and non-DG.
Well, no, it's just that at that point, it looks less and less. I mean, it begins to look like a real fixed charge at that point.
See,
And it's not, you're not trying to mitigate a problem. At that point, you're trying to do brain surgery with Black & Decker tools.
and then have an expectation the patient lives.
Well, it's just a very blunt instrument to deal with a very difficult problem.
Thank you for that. I just kind of want to kind of round out with a point you made earlier. You made a point that this docket has indicated that it's not an easy docket to resolve, correct?
Correct.
And there are going to be a number of winners and losers no matter what rate design comes out of this, correct?
Rate design is a zero-sum game.
So it'll be winners and losers, right? And during most of this hearing, we've been talking about the various impacts of these proposals and consequences as they relate to the ratepayer. Would you agree that's been a good chunk of the discussion the last couple of days?
Yes.
Now, as far as impacts going forward, if you were to go forward with Curb's proposal, one of the bigger impacts would obviously be the continuance of this perceived subsidy from DG class, correct?
Correct. Well, that's part of it, but part of it is, you know, you're basically waving a white flag at trying to deal with the problem right now.
Sure. Does the fact that Curb's proposal also represent a short-term solution provide any sort of, I guess, some comfort or support for it that way?
It's better than just returning the two-part rate.
Understandable, sure. And so as far as Curb proposals go, during your review of the testimony, does Curb's proposal present any sort of risk from a party about litigation or any legality issues regarding the two-part rate?
Boy, I would hope not.
Fair enough. And to your knowledge, if Curb's proposal to use a regulatory asset to track unrecovered fixed costs at any sort of particular rate, does that present any sort of meaningful risk to Evergy's credit rating over the next 3 years if that money is sitting in a regulatory asset?
I'm not a financial economist, and we have a guy here, Adam Gatewood, who can answer that question so much better than I can.
Fair enough. In regards to Evergy's operations, is there any predictions of any sort of meaningful reductions in any aspect of its operations due to the lack of funds associated with an under collection of fixed costs from DG customers at this time?
I'm not aware of them.
Thank you. I have no further questions.
Okay.
Thank you, Mr. Astrap. Now we turn to Mr. Bender.
Good afternoon, Dr. Glass. Can you hear me?
Yes.
Thanks. I have a few questions. To follow up on some questions from other parties mostly. So in response to Evergy's questions here, I think you agreed with the statement that there's a subsidy to the extent that DG customers are not paying their fair share of the utility's fixed costs. Do you recall that question?
Yes.
Okay. And then I believe you put a little bit more detail on it, which was they're not paying for their capacity requirements. Is that correct?
Yes.
And then I think I heard during your a series of answers to other questions, including from Mr. Flaherty, what sounded like 3 different definitions to me of what the DG customers' fair share or capacity requirements are. I'm going to see if we can get some more clarity around it. One was the use of $77, which was from Dr. Faruqi calculation in the 403 docket. Recall those questions?
Well, yes, Mr. Astrab asked me about that, but I mean, that was Dr. Faruqi's calculation based on Evergy's class cost of service in the docket, not based upon staff's.
Fair enough. But what Dr. Fruki did was add all customer and demand allocated costs together and effectively divided by number of meters in the class. Is that right?
Yes.
And then Mr. Flaherty was asking about if one sets the fixed charge at that level, what, you know, whichever cost of service one uses, but does that math, right? Customer and demand allocated divided by meters, that's the fixed charge, and then sets the rest of the rate at the variable charge, whether that takes care of the subsidy. And I think you answered that yes, it does. Is that right?
Okay, the qualification I believe I made was that, for example, there is a difference between an apartment and a home with 10,000 square feet. It wouldn't be my choice, but yes, I think it would mitigate most of the subsidy.
Okay. And so in that case, since we're defining subsidy based on whether or not the customer collects the $77 or give or take $77 a month as whether or not there's a subsidy, that's effectively assigning cost responsibility equally. Every customer having equal share of the cost responsibility for those categories of costs, correct?
That's the reason it's not my favorite rate design. That's the reason that I liked the demand charge, because it individualized customers.
Okay, we'll get there. I thought I heard another in response about, I believe from Commissioner Keene at the beginning of your testimony today on asking you about Mr. Gilliam's testimony and whether or not DG customers cause capacity costs. You recall that?
Yes.
Okay. And your response was, I believe, that it depends on what capacity cost you're talking about. And you gave the example of the distribution system capacity being a different time, the NCP hour measurement, than production capacity. Is that right?
Yeah, I think you're referring to a question that Ms. Dingus asked me. I'm not sure, but yes, that was my point, that the distribution system is allocated differently. Distribution costs are allocated differently. And usage of the distribution system can be different than usage of the whole system. The non-coincidental, that's the reason non-coincidental peak is used, because the distribution system is built for a region, not for the whole system.
Okay. I understand that. That sounds to me like we're using the cost of service study allocators as the measurement for fair share or capacity cost responsibility. Is that right?
She asked about a specific type of cost. And for that specific type of cost, I would argue that you would use that particular allocator, yes.
Okay, but I'm just trying to distinguish between, I mean, we can talk about, and you know, this is the cost of service study debate in every rate case, which is what allocators to use. But that to me sounds different from the first kind of definition of fair share that we talked about, which is essentially everybody gets the same share of fixed costs. And then moving away from that and into a kind of, we can talk about which allocators, but it's a cost of service allocation definition of fair share. Is that right?
Well, when you do a class cost of service, you put all the functionalized costs into demand, energy, customer. It is those three buckets that you look at the fair share part. That's That's why the commission found, and you know, I'm just repeating what the commission found in 403. If you reduce the energy usage and you don't reduce the demand in the same proportion, then you're not paying your part of the capacity costs.
Okay. So
That is the problem that DG customers create.
okay, that sounds to me like a third category or a third definition of fair share. So let me see if you agree. The first definition we talked about is essentially everyone gets an equal share regardless of your demand. You get $77, and that covers capacity costs and it covers customer costs. That was the first example. And the second being the allocators that we use, and there'll be different allocators for different demand categories, was the second. And I think what I just heard you say now, which is what I think I see in your testimony as well, is that fair share is defined based on your individual peak demand relative to your usage.
Well, it's actually the average customer. What I just described, the last one that I just described, was what came out of the 403 docket. That was the critique of the two-part rate design that the commission made. Now, the other two, I was asked specific questions. You know, Mr. Flaherty didn't ask me if that's what I wanted. If I thought that you know, an equal allocation of fixed costs, you know, on just a customer base, every customer gets the same amount. If I thought that was fair, and at one point I did hesitate. That's not there are lots of problems with a straight fixed variable. That's discussed in our comments. I think our initial comments, and I think just our initial comments. The second one, Ms. Dingus asked me about a specific cost. And she asked me if there was any cost that was created when a DG customer used energy at night. And I said, yes. And I gave that explanation of the non-coincidental peak and how that could create a cost on the distribution system. But for this docket, I mean, the subsidy has been defined by the commission. It's what I described last. It's what I described in my testimony. That is the subsidy that the commission identified.
But you agree with me that there are different ways to define fair share or the subsidy, correct?
Yes.
And so I think you're saying is in your testimony here, you used the third category, being a customer who has higher individual demand relative to that customer's usage, energy usage, receives a subsidy.
Correct.
Okay. And DG customers are a subset of those customers. On average, the DG customer will have individual demand higher than their energy use relative to the class as a whole, correct?
Correct.
But DG customers are not the only subset of customers that will be what sometimes is referred to as peaky, right? They have pretty high peaks, but low overall usage annually, correct?
I'm sure there are, yes. I'm sure there are other customers that are like that.
So you, in your pre-filed testimony in this case, you use an example of a DG customer who had a 9 kW individual peak during some hour of July and had
Yes.
net zero usage. You recall that?
Yes, I do.
So by your definition, that customer causes demand based on their individual peak hour sometime during the month of July, correct?
Correct.
But that hour is not necessarily at a hour that's a cost causer as defined by staff's cost of service study, correct?
Yeah, we don't know what hour it was.
Okay, did you look into the data, the load data, and find that
No,
customer?
there wasn't any load data. It was from their report. It was from the 2019 RSDG report.
So you don't know then what hour that load occurred in for your example customer, or for that matter, for any of the customers in that report, correct?
That's correct.
So we don't know then the correlation, if any, between those demands that you refer to in your testimony and system peak hours, correct?
Yeah, that's correct.
So a demand, 1 kW of demand would have equal cost responsibility regardless of what hour it occurs in, based on your testimony.
Well, what I used the price of demand. And the price of demand was $9.
Well, I'm asking about the demand itself. You identified individual customer peaks, for example, the 9 kW customer, and you use that regardless of when during the day or the week that demand occurred in, correct?
That's correct, yes.
And you agree with me that in staff's cost of service study, there are no production demand costs allocated based on individual customer peak demands, correct?
Oh yeah, it's system average. You're right. I mean, it's class average. Yes.
Okay. And production demand is allocated on a 4CP in staff's cost of service study, correct?
Production demand, yes, it's 4CP.
And there are no distribution demand costs allocated in staff's cost of service study based on individual customer peak demands, correct?
Well, we use an NCP. We use 12 NCP, I believe.
Right, and the NCP is not the sum of individual max demands. It's a specific hour that includes all load diversity during that hour, correct?
That's right, yes.
And so that's different than the individual customer peak demand cost responsibility that you used in your testimony, correct?
That's correct.
I don't think I have any further questions. Thank you.
Thank you.
Thank you, Mr. Bender. Staff, redirect, please.
Yes, thank you, Chair. Dr. Glass, could you please explain the distinction between a customer charge and the minimum bill?
Well, the customer charge, everybody has to pay it. The minimum bill, you only pay it if you use more than 278 kWh a month. The minimum bill is, the effective minimum bill is $20.50. The customer charge is $14.50. Minimum bill is $35. $14.50, subtract that. And so the minimum bill's effective rate is $20.50. And it applies to only those customers that fall into that category.
Okay, so as you said, the maximum impact of the minimum bill is $20.50, and that assumes zero usage.
Yes.
But as Brad Lutz presented, most customers would only see about a $1 increase a few months out of the year. Is that correct?
That's what he showed you.
Okay, I'm going to switch gears a little bit here next and ask, does Evergy have a low-income weatherization program?
Yes.
Would you say that Evergy has made a good faith effort to make that program successful?
Certainly in the last 5 years, they had a problem. But the program that I'm thinking of is actually in Johnson County. They had a problem distributing the money But then they worked with the Kansas Housing Authority or something. I don't remember who it was. I don't remember the name, the specific name, but we actually checked out that group in 2012, 2013, and they're very good. They at least they fooled us, and they now just give the money to them, and they are responsible for what they do with it, and then they provide a report back to Evergy. They show them purchase orders, etc., that justifies how they spent the money, and then they also match Evergy's money with other people's money, so there is a multiplier effect there too. So yes, I would call it a good faith effort.
And do you have any reason to believe that Evergy wouldn't make that same good faith effort to implement a low income assistance program?
No, I mean, Evergy's always been pretty straightforward about this type of stuff.
Now, switching gears again, assuming Mr. Gillum's argument that DG customers use the system at off-peak times, does that mean that it would then be fair to use that system for free?
Well, no. There's a similar argument almost in the natural gas industry. They use a minimum system, and then they basically argue that that system, when that pipe isn't being used, the use of it is free. That sort of violates the concept of the way that you have to allocate stuff. In the back of my head, when I think about allocation, and I try to think about allocating a system, a part of a system, I think in terms of something like what's known as the Shapley value in game theory. It's a solution concept. And if I explain it to you, it'll sound unbelievably complex, but it makes great intuitive sense if you're an economist. What you do is you take the incremental cost of everybody in every situation when they join the system. So if they're the first to join, what's their incremental cost? If they're the last to join, what's their incremental cost? You take all those incremental costs and average them. Basically, what this is doing is taking the average marginal cost. And that's the way that I think of, of allocating a network that has multiple parts that, some parts are used differently than others, but it's all one whole. And so, residential customers join, and then you have an industrial customer. Well, you can't just charge the industrial customer the incremental cost. You have to charge them more than the incremental cost, because if there weren't the residential customers, there wouldn't be that system for them to join, and they wouldn't be able to pay the incremental cost. So that's the way that I think of it. Thinking of it that way, even if you use something when nobody else is using it, it's still, you have to think about that. What if you were using it and that you wanted to use it and it didn't exist? What would be your incremental cost? You have to take those types of things into account when you allocate, or I think you violate a general principle of fairness. I think. Again, I'm not very good at absolutes, so I could be wrong on this, and have been many times.
Well, thank you for your response. And I'm going to switch gears on you again for my final question. Earlier, when you were being cross-examined by Mr. Flaherty, he was kind of touching on principles that to me described a straight fixed variable design or something similar to that. Would a straight fixed variable eliminate the subsidy? I believe you may have already answered in the affirmative to that, but.
Yeah, the problem with straight fixed variable is the fairness. because, you know, they, again, you know, if you think about the allocation of all the fixed costs, well, an apartment, their incremental costs are going to be smaller at every instant. So they should probably have a lower fixed cost. One of the rate designs in 403 that the commission said that they would approve was a tiered fixed cost, a tiered customer charge. Well, if you tiered it and you based it upon square footage, you base it upon apartment versus house versus monstrous house, something like that, then, you know, it's much closer to being fair. You're still gonna, you know, as long as the energy charge only collects energy costs, you're gonna eliminate the subsidy, but you're gonna have a real problem with fairness unless you also differentiate the fixed cost. This is one of the reasons that the demand charge, you know, has a certain, that there's a certain aspect to it that I see as more fair because the individual customer can control their demand to some extent. So it's called a fixed charge, but there is a variable aspect to it. And given my conversations with Butler Community College, people can make dramatic changes in their use, in their demand use. So that's probably too much answer for your question. I'm sorry.
No, that was great. Thank you. It does lead me to one further question, I suppose, though. Touching on that issue of fairness that you brought up. So even though a straight fixed variable rate might eliminate the subsidy, wouldn't it also necessarily substantially increase the customer charge?
Oh yeah, it has to, yeah.
Right. All right, well, I believe I have no further questions for you, Dr. Glass. Thank you.
Thank you, Ms. Massentine. We will look to Pioneer, Ms. Kafer,
No questions, thanks.
Liberty Empire, Mr. Flaherty.
No questions, thank you.
Thank you. KIC, Mr. Vincent,
No questions, thank you.
Ms. Cunningham,
No questions, thank you.
and Mr. Astrab,
No questions, thank you.
and Mr. Bender.
No questions. Thank you.
So, commissioners, and if I may start with Commissioner French.
And before I begin, I don't know if Evergy just didn't have recross. I see they're not listed on the sheet.
They're not listed.
But I wanted to give the opportunity.
Thank you. I don't have anything. Thank you, Commissioner.
Thank you. I do have one. Good afternoon, Dr. Glass. I had 6 lines of questioning, but the benefit of going after everyone is that I eliminated 5 of them because I got great answers to pretty much everything I had to ask. I was really glad or really interested, I guess, to hear you call the minimum bill a stopgap intermediate measure. Because I literally had a line of questioning where I was going to ask you whether you saw the minimum bill as a stopgap measure until we could implement a perhaps more holistic or more elegant approach like those advocated by Mr. Lutz or Mr. Gilliam. So I'll move past that line of questioning because I see that you do believe minimum bill is a stopgap intermediate measure. My thinking is this: if we agree we have some sort of rate design problem here, and that we need to get to a new solution in the future, and perhaps we need to implement some sort of stopgap, maybe even with a sunset period. Well, I guess my question is about the need to implement a stopgap measure. There has been testimony about what the size of the subsidy is, or I suppose in this case, if we returned everybody to a two-part rate design, it wouldn't so much be a subsidy as you would have a revenue hole for Evergy if we did that right away. Do you believe that that revenue hole is material enough that we do need to institute some sort of stopgap measure before the next rate case, something like either a minimum bill or curbs accounting treatment process to make sure we track revenues? What is your opinion on the need for a stopgap measure compared to the size of revenue that we're dealing with here?
Well, first, the way that the demand charge was set, it was negotiated, but the way it was set, we set the Evergy agreed with $3 and $9 for the demand charge. Customer charge was $14.50. Then you just solve for the energy charge. What we did was we tried to set it up using the billing determinants in the 328. We tried to set it up so that if the same DG customer were on, well, if the average DG customer were on the two-part rate, or if they were on the three-part rate, they would pay the same amount. Actually, we didn't hit it exactly, although I will brag that I did in my testimony and in my proposal, hit it exactly. But that was coincidence. You know, it's very hard to hit things exactly, but they're very close. So there should be very little, I mean, just based upon the billing determinants, there should be very little revenue lost by the company for those existing customers. The problem with all the estimates of the demand and all of the estimates of the subsidy is that if you go back and you look at the billing determinants, you look at the billing determinants and you look at the RSDG class in the actual rate case, the 328 rate case. If you look at them, they're kind of a mess. Started out with 65 customers in July 2016. You ended up with 227 in June 2017. That's a dynamic class, and class cost of service is, I mean, every time you ever read anything about class cost of service, right? Every class cost of service person says it's an art, blah, 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 and it's a snapshot. Well, a snapshot is not going to catch a class that goes from 65 to 227. And you notice that the number that was used by Dr. Faruqi was 156, which is basically the average. The reason that staff's billing determinants were significantly different was we saw that dynamic aspect. And so we tried to use a customer adjustment. Just to be honest, it didn't work. I don't think anything would have worked. To use a class cost of service on Evergy Central's DG class, I think there's a good chance that in 2023 or 2022, the next rate case, there will be enough customers, it'll be settled enough that you will have a better understanding of what the costs are, what the subsidy is, what needs to be done. But right now, I mean, going back and looking at a test year that's almost 3.5 years old at its end, it's very difficult. And that's the reason that the numbers look at different times, you get radically different numbers and they look kind of screwy. That's also the reason we chose $3 and $9 rather than $28, $17, $9, I mean, or $11, I'm sorry. we wanted to make sure that the demand charge was significantly lower than what it should be to fully capture what we thought the subsidy was.
So I guess what I'm hearing in response to my question is, if we were to switch everyone back to the two-part rate, you wouldn't necessarily or inherently see a revenue loss to the company, because those rates were set up to collect the same, or they were set up from the same billing determinants to collect the same revenue. But perhaps it's safer to do a minimum bill or to do an accounting treatment, but not necessarily mandatory in your view.
Well, as I said, it's based upon, you know, something 3.5 years ago, and the class has changed dramatically. One of the things I did, it was in our comments, I believe. We went and looked, and we estimated, you know, from that RSDG report, what average demand was for DG customers, what average, and then we went back to the rate case and looked at what average demand was for regular residential customers. RSDG customers, their demand was twice, more than twice what average customers were. So my guess is that the systems have gotten bigger as they've gotten cheaper. I would suspect that Evergy is going to take a bigger hit in revenue than they would have 3.5 years ago. 3.5 years ago, it would have been a couple $100, maybe 1,000, maybe 1,500. Now, you know, it could be significant money. So I would like to be careful, because, you know, you always want if the utility has earned the right to recover a certain amount of money, you want to give them that opportunity.
Absolutely. I agree with that. I think I share your sentiment about being careful. I think, you know, on the other side, would you have a concern, you know, about implementing something like a minimum bill, you know, for 3 years and then taking it away? Does that, in your view, cause customer confusion? And should that be a consideration, or is it, or should that not be a consideration? It's just a good, careful thing to do.
Well, given the fact that very few bills are going to be affected by it, I think that it's the type of thing that will pass in the night and most customers won't even recognize it.
Thank you. I don't have anything further. Thank you.
Commissioner King,
No further questions from me. Thank you.
thank you. Dr. Glass, just a couple, please. Should a customer, a DG customer that generates electricity back on the grid, be treated any differently than one who does not?
A DG customer that doesn't?
Yes.
Well, there is that export function. If they, for some reason they don't export, they don't ever export, then that's a service they're not using. I don't know the value of that service. I've actually looked at estimates, and I've seen estimates, you know, huge span, huge, you know, depending on if you're a DG customer advocate, you know, the benefits are huge. If you're a utility, the costs are monstrous. I've only seen one real study that I would call academic that seemed to be in the middle. And they basically said that if you add all the things that they could estimate, that they chose to estimate, and it was a very narrow study, and they used simulations, but I did give it to our engineers, you know, to have them check it, because I can't be trusted with engineering stuff. Their basic conclusion was there are actually small benefits to DG customers who export. And those benefits probably outweigh the costs of providing the service of exporting. But they also found, and they did this with simulations, that a lot of the answer depended upon climate, upon topography, and upon the feeder system, and that there was an enormous range of possibilities of possible costs. So this is a long way to get to, if there is a charge for getting onto the system, I would expect that charge to be very minimal, much like there used to be a charge if you had a second meter for space heating, and it was like $2.50. I would imagine it would be something like that. But I'm not sure. I don't think so. There probably are minimal benefits, very small benefits, 0.2 of a cent, something like that, for the exporting. So I would say that there really is not much difference to the DG customer that never exports and the DG customer that does export.
Okay, so let's put it a different way. All along, we've been talking about that there has been a cost to others because of these DG customers. So if we assume that rooftop solar here in Kansas, let's say it's making up 1% of the peak load limit, because that seems to be, it kind of mirrors that to a certain extent. All right, so the other 99% of the customers are paying for that transmission of the transmission costs. So is there a benefit to the other 99% by having DG solar customers on the grid?
Well, the study that I just outlined said very de minimis, 0.2 of a cent.
So if they all went away tomorrow,
right,
all of them turned off, and it is July 14th, and it's 103 degrees outside, Evergy would not have any problem at all meeting its peak load on a Friday afternoon.
Well, I mean, if Wolf Creek is running, if there are no major transmission lines down, I would say yes, they should. That would not be a problem.
So the effect of them not being on the system really would not negatively impact the system. Because
I think
their contribution is so small.
No, I think that their effect on the system is pretty neutral in that sense, but they are, being on the system, they're like every other customer on the system. They are requiring capacity, and they have customer costs, billing and stuff like that. So they still have those costs by being on the system.
They are a customer first before they are a DG customer, meaning they get a bill in the mail or whatever, a meter is out there on their property, a line had to be taken, to serve them. Okay. All right. And let me look here real quick. So I don't believe you ever used the word gradualism in your testimony.
It would be a first time.
Was that purposeful?
Well, if we would have if we would have found a way to say yes to the grid charge, then there would have been a lot of talk of gradualism. But with the minimum bill, it already is gradual, in my point of view, at $35. There wasn't any need to really go into, I mean, it's the fact that it affects so few customers, so few bills, indicates to me that it's not going to have a dramatic impact.
At $35 that won't, but at 77, what is the time frame, assuming nothing else happens except more DGs get on the system? At what point do we reach 77? Because the company states 77 is actually what they need. 35 is just we'll cut it in half and call it good. So are we talking a couple of years, and how do we ignore the company's request to fulfill the shortfall?
I cannot imagine three commissioners agreeing to $77 minimum charge under almost any circumstances. I think that if Evergy were to come in and say, no, we can't think of anything else, we want a $45 minimum bill, I think that there would be very strong pushback, and I doubt that it would increase. I just don't see a minimum bill going up much at all, if at all, because it's as I said, it's a sledgehammer approach to a problem. It's not, there's not a it's not a refined approach. There's, as Commissioner French said, there's nothing elegant about it. I would hope that Evergy would come up with something better. I think they will. Brad Lutz is a very smart guy. There are a lot of smart people at Evergy. I'm pretty sure they're going to be able to come up with something better.
Okay, thank you. With that, I believe that concludes all of our witnesses for today. Mr. Fedotin, are you on? I'm not seeing you. There you are. So we have some issues before we conclude our hearing. Other issues, is that correct?
I don't know that we have much in the way of issues, just in case we wanted to remind the parties about post-hearing briefs and what anything the commission wants to include in post-hearing briefs. But and then just to remind the parties to look at their chat and contact the court reporter. But in terms of actual issues, I don't think there are any that I can remember.
Okay, so concerning post-hearing briefs, I think we raised those several. Let me look here.
The post-hearing briefs are due January 11th.
Yes, I'm looking for the date and I don't see it here.
January 11th.
Okay, all right, thank you. That's what I was looking for. Okay.
And the public comment period for those members of the public that are listening and wish to make comments, they have till 5 p.m. on Monday, December 21st to submit any comments to our PACP, and those would also become part of the record.
Yes, thank you. So with that, this does conclude our hearing on docket 18 WSEE 328 RTS. The commission's decision is due February 25th, 2021. And yes, the public comment period will run through 5 p.m. on December 21st. So you have the ability to send it to us in the mail or go out online and send it on the internet and send it to us that way. Thank you very much. I do want to acknowledge all of you for doing a great job in terms of a Zoom meeting. Again, we continue to, I think, use this technique well, and we're all getting pretty good at it. So I appreciate you hanging in there, and please stay well, be safe, and we'll visit again someday. Thank you.
Thank you.
We are adjourned.
Thank you.
Mr. Fedortin or IT, please don't take down, knock me out until I have a chance to read the chat room, please.
Michelle?
There had been no additional comments in the chat room other than what you sent to everybody.
I show 4 messages I haven't read yet.
I don't think I received a message from the court reporter. I don't know if I was supposed to, but I don't have anything in my chat.